Item number 3.
There is no representation on behalf of the petitioner today on call. Mr. MP Goswami, learned additional public prosecutor for the respondent state is in attendance in view of non-representation. Come on, let the case be listed after a week on the date to be fixed by the office.
Item 4.
May it please your worship. Mr. I am the informant and victim in a cheating case, my lord.
Hmm?
I am the informant and victim in a cheating case. Subsequently, my lord, during trial, I gave an application to assist the learned public prosecutor in the trial. That was allowed, and then I found out, my lord, that two very vital witnesses, they had not been examined, and even the IO had not been examined. So I filed an application under 311 of the CRPC through the PP to call those two witnesses and as well as the IO who had not been examined. And that prayer had been rejected by the learned trial court, saying that, first of all, citing Zahira Habibullah Sheikh wrongly and saying that it would amount to filling up of the lacuna of the case. And secondly, that this prayer had come at a belated stage. And so the prayer was rejected, my lord. Your lordship will kindly come, first of all, my lord, to page number 34, my lord. Your lordship has page 34, my lord.
Yes.
So page 34, my lord. The evidence of PW, Shofiquddin and Riazul Hussain, my lord. These are two witnesses cited in the charge sheet. Because bailable warrant had been issued against these two witnesses. And when these bailable warrants were not returned, then, my lord, on the prayer of the learned APP, these two witnesses, the evidence of these two witnesses was closed. Now, your lordship will kindly come to an additional affidavit, my lord, which we have filed. That is at page 42, my lord. Page 42, here citing that the case had been pending for evidence for a long time. And on the last day,
Page
the 42, my lord. On perusal of the case record, it is seen that the case is pending at the stage of evidence for a long time. The record reveals that on the previous date, that is on 22/8/23, the prosecution was given a last opportunity to bring its witnesses. However, no witnesses are present today. Now, right to speedy trial is one of the constitutional rights given to an accused, and violation of it is an infringement of his fundamental rights. The prosecution, despite being given ample opportunities, has failed to procure the attendance of its witnesses. So the prosecution evidence was closed and the case was fixed for SD. Now, my lord, on page 43, that is on 14/5/25, my lord, because initially, after giving my evidence, my lord, I had no idea what was going on. On 14/5/25, I filed an application for allowing me to assist the learned PP. This application was allowed, my lord. And the case was fixed for argument on 21/5/25. Now, on hereafter, my lord will kindly come back to page 35. Here I made the application through the PP, my lord. I filed an application under 311 CRPC for calling these two witnesses and the IO. Their evidence is vital, saying that their evidence is vital and they should be examined. May I read this order, my lord? Heard both sides on petition number so and so filed by the prosecution side under section 311 CRPC. The learned APP on behalf of the state has submitted that the witnesses that are mentioned in the petition are very important as they will help in proper adjudication of the case. The defense strongly objected the petition by stating that the said witnesses were dispensed at the prayer of the prosecution side. So far as the IO is concerned, the prosecution was given the last opportunity. The evidence of the IO was closed only because the prosecution could not produce him on given opportunity. Peruse the CR. On perusal of the CR, it appears that the court, while order dated 13/2/23, dispensed evidence of witnesses, namely Shofiquddin and Riazul Hussain, only on the prayer of the learned APP, as both summons and was duly served on both the witnesses, but they did not turn up. So far as the IO is concerned, the prosecution was given the last opportunity, but the prosecution failed. Thus, for all the witnesses, the prosecution got ample opportunity, but could not produce the witnesses. The petition under section 311 CRPC was filed at the stage of argument, and prosecution witnesses was closed by order dated 9/10/23. The court fails to understand why the prosecution took 1.5 years to file the evidence. I also take note of the case of Zahira Habibullah Sheikh and another reported in so and so, whereby Honorable Supreme Court has stated that the power vested under section 311 CRPC should not be allowed to fill up lacuna at a later stage. Here, the evidence of the witnesses were closed only at the instance of the prosecution. Allowing the petition at this stage will only help the prosecution to fill up the lacuna and will prejudice the accused person.
Where is your petition?
Petition, we have not annexed, my lord. But because it's
Court has to exercise
my lord.
the discretion.
Yeah.
Because that has to be
My lord.
exercised, that discretion has to be exercised with care and caution,
My lord.
right? Where is your, what are your the regions?
Because my lord, this petition
Yeah.
was filed by the prosecution, my lord. And only thing which I am trying to submit, my lord, is
Because
that
it is a closed chapter. It
Closed
has
chapter.
to be opened.
my lord.
So for that,
Yes, ma'am.
some regions are to be assigned by the APP also, even if he is aided by council under section 302 CRPC. But what are the regions?
Is that petition, my lord? we
It
don't
could
have
be,
the
it could be either way.
petition, my lord.
It could be either way. The court has to exercise the discretion with care and caution.
My lord.
There are two parts to 311.
311.
Whether for the just decision of the case, it is required or not required, court has to see the regions assigned.
But one thing which I'm like to humbly submit.
Because for what purpose
My lord.
that two witnesses are required. And that is dependent upon 161 also. Is it not? Just for the asking you cannot.
It will not come, my lord. Here, my lord.
It cannot be an ipse dixit of the
My lord.
petitioner's counsel or APP. What are the regions?
The one thing which I'm like trying to submit, my lord, is that these two witnesses
Are cited witnesses.
were
Okay.
cited witnesses.
But their statements are also there.
Their
That means
statements, my lord, are not furnished to me. So, my lord, I will not be privy to their statements, my lord.
you are aiding the PP.
PP, but my lord, still, my lord, my role is only that of an assistant, my lord. So copies will be with the PP. PP is not required by law to give those to me. So I do not know that, but I know for a fact that these two witnesses, they were privy to the transaction. That whole, my lord,
What is your petition basically?
my petition, that part, my lord, I admit that petition is not there.
Because court has to exercise their discretion, and for that purpose, whether court has rightly exercised the discretion or has erred in exercising a discretion, that can be seen only from the petition. What are the reasons assigned? Because just because they are listed witnesses, otherwise prosecution has the discretion also
Yes,
to call witnesses, to drop witnesses. Right?
yes, my lord.
So I don't know the reason.
But one thing which
If said, Dixit will not do.
one thing I'm trying to submit, my lord, is that IO, my lord, IO is a vital witness because IO has done the investigation, and non-examination of the IO, depending on the facts and circumstances of the case, can also be fatal to the prosecution's case, my lord. Here, IO was not examined only because last opportunity was given, my lord.
Well, let's see what kind of nature of allegation you have
Yes.
made.
And one thing, my lord, just, my lord, I'm sorry for interrupting.
Why this prosecution has been initiated?
Yes, my lord. That complaint will lordship will find at page 20. It's a very long complaint, but I'll give the gist, my lord. This informant, my lord, she was married to a person, and then, my lord, subsequently there was marital discord between them, which led to the initiation of multiple cases between the informant and her husband. Subsequently, this issue was sorted out between the informant and her former husband. And one of the conditions was that the husband was going to pay a sum of rupees 1,20,000 to the informant. And for payment of this sum of money, the informant readily agreed to withdraw the money. Now, the respondent number 2, who happens to be the accused of the case, my lord, he took that sum of money on behalf of the informant, my lord. And subsequently, he did not pay the money because the informant gave her consent for withdrawal of the cases on the bona fide belief that this money will be given to me. But this accused, my lord, he did not. He took the money, he paid half of it, and half of it he misappropriated, my lord. And these two.
How these two witnesses
These two
were
witnesses,
living?
my lord, when there was a village meeting which was held, my lord, where this money was paid to the accused person, and they were privy to this transaction, my lord. And what the learned court has done, my lord.
What did you do in the petition?
My lord.
What did you do in the petition?
On petition, we only cited that these two, that from my instruction goes, that these two witnesses, because I came in at a very belated stage, my lord.
Whatever.
And then I said that these two witnesses.
Whatever, you were privy to the role
Yes,
to
I
be
am
played by these
witnesses,
witnesses.
my lord. So, my lord, I told that these two witnesses are vital, as well as the IO. Because without the IO, the way this investigation was conducted, this could not have been found out. So this.
Merely vital will not do, sir.
But my submission is, my lord, respectful submission is that these two witnesses, since they were
But this-
cited witnesses by the prosecution, and court, just because the court could not.
Because APP has the discretion also to drop witnesses.
Yes, my lord.
Right?
Yes.
He may have exercised his discretion.
Yes, my lord.
Right?
Right.
Now, at a fag end
Yes.
or a trial, after the appointment of counsel in aid of the PP, wisdom has prevailed now to the on the PP to submit an application, right? For the court to invoke 311, right? First part goes, first part is not there. Second part, for the just decision. So what you have highlighted, because this is a discretionary power,
Right.
not that on a
Second
if
part
say
is-
Dixit no.
But
No,
second,
so
second.
why you have not, because we have to exercise our discretion on the petition.
My lord.
Merely if say Dixit will not do.
But I am relying on two judgments on this point, that if there may be an error on the part of either side, prosecution or the defense, to bring forward relevant evidence at the correct time. But if evidence is available, which is otherwise essential for the decision of the case, here IO is
Mr.
essential.
Nawaz, it cuts both sides.
My lord.
It cuts both ways.
My lord.
We have to see, we have to exercise our discretion, whether the trial court has exercised its discretion correctly or not, right? And the most vital piece of document is the application seeking recall, or calling the witnesses,
Calling the witnesses.
right? So ipse dixit will not do,
My lord.
because it could be that just for harassing the accused, you want to prolong the prosecution.
That can also be.
That can also
be-
be, right? Both, it cuts both ways.
Both ways, my lord.
Just because at the fag end you have appointed a counsel and vice sense prevailed upon the APP because of the aid received from the counsel, we have to see why.
Well, even the evidence of those
Get
two
the
witnesses-
application
Well,
on
I'll
record.
get to the
And we
but
can-
just one submission, my lord, if your lordship permits, my lord. Even if the two witnesses, my lord, those two witnesses are, because those two witnesses had, evidence had been closed on the prayer of the APP. But the evidence of the IO was closed suo moto by the learned trial court.
That is also a part of the application.
Yes, my lord.
What role what vital evidence he ought to have adduced for the purpose of the prosecution side. That is also to be brought on
Because, my lord,
record.
Non-examination of IO could
Non-examination
otherwise-
is also not fatal.
Depending on the case, my lord,
Depending on the case, facts to case, every case is,
factual, my lord.
as Honorable Justice Tulia has said, the judge has to be a
Judge of
judge of
my lord.
facts.
Facts, my lord.
then law. So these are the facts.
One-
Then 311.
One thing which a learned court has
Please bring
cited,
it.
my lord. I'll bring it,
Otherwise-
my lord. One thing which a learned court has cited, Zahira Habibullah Sheikh, completely wrong. Well, that is not, the ratio is the complete opposite, my lord.
We'll not look into it. Show us. You have already taken 3 weeks' time to file additional affidavit, and the
These
most
orders-
vital piece of document is not there.
My lord. These orders had also not been annexed, my lord. I had also come in later in the case, my lord. So I'll try to get the order, my application, my lord.
Because to exercise, this is already extraordinary power
My lord.
for just decision of the case. And you have to point out that their examination is vital for the just decision of the case. How many witnesses have been examined?
Others have all been examined.
How many?
My lord, I'm just giving
It
the
speaks
list.
for argument.
Right? How many?
My lord, 5 witnesses have been examined, my lord.
5
5
witnesses.
witnesses have been examined.
Could be enough also.
Without the IO, my lord, it will be difficult to, without the IO, because
What
that
will be
Lahu
fatal?
Commonwealth has-
What will be the fatality?
my lord, the,
So
my lord, the,
point us.
My lord, again, for that reports will be required, but my lord, if the witnesses, the manner in which these transactions were
You have the
developed.
testimony of 5 witnesses. And what is missing, you say, and also the application, the region assigned.
Application, my lord, I will try to get the application.
You get the application.
My lord.
As soon as we can fix it. We can fix it on a particular date.
My lord.
You get the application and record. Because I have come across many 311 without anything.
My lord.
Absolutely nothing. Justice machinery cannot be utilized
Whimsically cannot be related.
for oblique purposes.
My lord. That is, my lord.
We have to see that.
See the, my
You have
lord.
missed the bus, miss the bus.
Yes.
We cannot board the bus later on, after the bus has left the station. When you want.
My lord, 22nd, my lord.
Okay. On the prayer of Mr. S. Nawaz, learned counsel for the petition, and raised the case on 22nd. The petitioner side has sought time to bring the application submitted under section 311 CRPC on record.
My lord. Deeply opposed.
Item 5.
May I please, Your Lordship?
Yes.
Lordship, the instant criminal petition is arising out of a matrimonial dispute, Your Lordship. So where my
Why so bulky?
Lordship, what had happened in this case, my wife has filed numerous cases against me, Your Lordship. So out of
Yes,
which I
Mr.
have,
Goswami.
Yes.
But still that court entered in. I will not go into that aspect.
So court has come to a finding that
Right.
relying on a forensic report that
It says we'll proceed.
yes, proceed. We don't have it. Because
Proceed and Mr.
I've already cross-examined the witness. That part we okay. My question is that since
There is no shortcut.
there is no shortcut.
This shortcut is not appealable to this court.
No, I'm not praying for shortcut, nothing, my lord. My question is that that report cannot be taken until it is legally proved in a section case. Because
It will be proved, whatever, whether it will be proved or not proved.
yes, but
Right.
that
There are three things:
So-
proved, not proved, disproved. All things are available.
yes, yes. Yeah, but my only observation that this petition we regarding the validity of the report
That will be
look
looked into by the learned court during the course of the proceedings of this thing.
in accordance with law. But that
In accordance with law only.
that part only.
Lordship, what my learned senior friend is submitting, my lord, I have some different opinion regarding that, my lord. Regarding the decision that has been relied upon, my lord. My lord, this decision is, the facts are completely different.
No,
Here, my lord, yes,
from there we can
Yeah.
understand
yes, my
how a DNA
Can be-
report can
yes.
be proved.
proof, my lord.
Right, brought
Yes.
on record,
Yes,
then whether, how,
Yes. Yeah.
what kind of defense can be taken.
yes, yes,
We can
Yes, sir.
understand, we can
Yes.
have some knowledge, we
Yes.
have gathered knowledge
Lordship,
from this.
yes,
But here is a different
Yes, sir.
thing. Here
Here-
is this
Yes.
case is a different one.
yes.
completely-
This is
But
regarding, my lord.
That is a guidance. You have
Yes.
got knowledge
Yes,
after reading it.
yes,
I have got knowledge,
Lordship,
right?
that is,
What kind of defense
yes, yes,
can be done
yes,
or merely under section
Yes.
294 CRPC
yes,
by the IO,
yes,
right?
Of the report.
So
Yes.
you have, so when
Yes, that-
other case comes,
yes.
you can argue on it
Ye-
after getting
ye-
this
ye-
knowledge,
Yes, sir. It is a great, yeah, that part, I agree.
right?
Yes,
I have also gathered
You
knowledge.
get
Academic knowledge has come.
That-
Academic knowledge
Yes.
has come and that will be very
Academic has come.
beneficial
Yes.
for other cases.
Further, that is what,
Ah.
yes. And now,
But
my-
here we don't find any case.
yes, because my lord, in my lord, 125 proceeding, that is now my lord 145, my lord, that is a my lord beneficial. legislation.
Illegitimate
Yes, illegitimate,
Ah.
man.
I understand.
son or daughter
Yes.
has a right to claim, and that has been observed.
Yes,
And ultimately, finality, that is an interim observation.
yes,
That finality cannot be attached to that observation. Ultimately, it is a
Yes.
final order.
yes,
And that is a basis.
yes,
And legality, validity, and acceptability of
Yes.
the DNA report will
Yes.
be looked into by the court.
Yes, that observation.
Lordship. Yes, I am taking lordship 2-3 minutes, my lord, for my lord. Just-
Yes.
Yes, lord. My lord, regarding the procedure that,
Nagori,
yes, my lord, BNSS, my lord,
BNSS.
there's a 144
1 minute, 1 minute.
lordship. Your lordship will find, my lord.
1 minute. Doctor, what doctor? 1 minute. 1 minute.
Lordship,
এইটো ওলাব যাওঁতে খৰচ উলিয়াই যাব বৰ দিগদাৰ হৈছে এনেকৈ ওপৰত মাৰিব লাগিব চাওঁ আৰু এইটো লাগি থাকিলে বৰ দিগদাৰ নহয় লাগিছে কেতিয়াবা বুজি পালো আৰু হা Yes.
yes, one lordship may find in 144, my lord, regarding
Yes.
maintenance, my lord. Earlier it is 125, my lord. You'll straight away, my lord, I am taking to lordships 1B lordship. Here it is very specifically, my lord, mentioned,
Huh.
my lord. Any person refuses to neglect legitimate or illegitimate minor child, my lord.
Huh.
So that part is gone regarding the, one part, my lord. Next, my lord.
Whether he is
Uh,
legitimate or
Yes.
illegitimate is
Yes.
dependent on that
yes,
acceptability of the DNA report.
DNA report.
Right.
That is one. And second, my lord, if we go by the procedure, my lord.
If that goes,
Yes,
then claim goes.
claim goes, my lord. And lordship will come to, my lord, 145 procedure, my lord. Regarding the, my lord, proceedings under section 144 may be taken against.
Which
145, next.
One
section,
forty, procedure.
Procedure, my lord.
140, yes.
Lordship. Here your lordship will find, my lord,
Huh.
section 2, my lord. All evidences in such proceedings shall be taken in the presence of person against whom an order for payment of maintenance is proposed to be made, or when personal attendance dispensed with in the presence of his advocate shall be recorded in the manner prescribed for summons cases, my lord. This is unlike the, my lord, the decision that has been rendered, it is different. That is what I like to stress, my lord. It's a beneficial legislation, my lord.
Hmm.
So at this stage, my lord, so whether it is proved or not will
We
not
cannot
have a
jump
bearing.
into conclusion now
Yes, there.
on the DNA report.
Yes, and there, my lord, one judgment I have found, my lord, that is in the, I have given a printout, my lord, that is, it is supreme to the, my lord, that is also 2022 5 Supreme 138, my lord. Here also, my lord, a DNA regarding the, a DNA report was ordered, my lord, when the father dispute the paternity, my lord, a DNA report is ordered, my lord. But what the learned honorable court, apex court has held that, my lord, without, my lord, a conditional order was given, my lord. The DNA, when DNA report comes, my lord, if it is positive, you have to give 30 lakhs of rupees, my lord. So after getting the DNA report, my lord, the defense that is available to him is not taken care of by this decision. Once the DNA report comes, my lord, he has to give the maintenance, my lord. So maintenance order starts there, my lord. So whether it is a matter of challenge or not, that is not taken up. Your lordship will find in the third page, my lord, paragraph 3, my paragraph 3, my lord. Third paragraph, my lord. Yes. Paragraph 3 and 4, lordship. It is made absolutely clear that if on testing it is found that allegations are based on suspicion that respondent is in fact the father of the child, respondent shall pay compensation of 30 lakhs to the petitioner, my lord. That is, it was stopped there, my lord, regarding the payment, my lord. Now, whether he challenged or not, that is the separate issue. That is what I want to stress on this.
This is by whom?
This is why, my lord,
Supreme Court. Okay.
Honorable Justice,
Huh.
my lord, India Banerjee and A.S. Bopana, my lord.
Heard Mr. P. Kotoki. Like counsel for the petitioner. Prosto. the instant criminal petition under section 528 Bharatiya Nagorik Surakha Honita 2023 is preferred to assail legality and validity of an order dated 23/4/2025 passed by the Court of Learned Judicial Magistrate First Class Bongaigaon Trial Court in Miss Case number 41/2024, which arose out of Sessions Case number 23 of 2024. No, full stop. Which arose out of Nalagi. Where the events leading to the passing of the order dated 23/4/2025 in Miss Case number 41 of 2024 can be narrated at first. The prior events. Full stop. The respondent number one, sorry, the respondent, sole respondent, implicated herein had lodged, as the informant had lodged a first information report before the officer in charge, Bongaigaon Police Station, Hodor, on 1/2/2023, alleging inter alia to the effect that she worked in a chamber of the petitioner, who is a doctor by profession. Full stop. During the tenure, in a period when the informant was so working, a relationship, a physical relationship developed between them, and the same lasted for about 4 years. Post of the informant had alleged that the accused, that is the petitioner, made her abort her pregnancy on 2 occasions. But on the 3rd occasion, she managed to give birth to a child on 3/2/2023 at Bongaigaon Swagat Hospital by maintaining distance from the accused. But the accused denied paternity of the child so born. The informant further alleged that when she asked for maintenance of her child from the accused, she was threatened. The said FIR was registered as Bongaigaon Police Station case number 41/2023 under section 362 (2) stroke 493 stroke 507, Indian Penal Code. And the matter was investigated into. Where upon completion of investigation, the investigating officer of the case submitted a charge sheet under section 173(2) CRPC by charge sheet number 17/2000. 17/6 on 36/2023, stating that sufficient incriminating materials were found against the accused for him to stand in a trial for charges under section, for offences under section 360, 376(2)(d) stroke 493 stroke 506 IPC. Poster. In the charge sheet, the IO further mentioned that during the course of investigation, blood samples of the accused, the informant, and a newborn baby were collected and sent to the forensic science laboratory for examination. Post op. The reports from the forensic science laboratory were also collected, and the case against the accused was found established on the basis of the FSL reports. FSL means DNA reports. DNA, within bracket DNA reports. And evidence of other witnesses. Post op. The FSL reports within bracket DNA report was submitted, was forwarded by the scientific officer, DNA typing unit, Directorate of Forensic Science, Assam, to the investigating authority through Violent Office Letter 20, page 21 of the Directorate of the dated 12/5/2023 of the Directorate of Forensic Science, Assam. Post op. The copy of the DNA report is found annexed to the instant petition. Post op para. From the materials on record, it is stated, in this criminal petition, the petitioner has stated that it is on the basis of the DNA report dated 12/5/2023, the respondent hearing, that is the informant in so-and-so case number, police station case number, file an application before the Court of Law and Chief Judicial Magistrate at Bongaigaon under section 144 of the BNSS seeking maintenance amount of rupees 25,000 each for herself and for the minor child who was born on 3/1/2023. Full stop. The said application was registered as Miss Case number 41 of 2024 and is presently pending before the Court of Learned Judicial Magistrate First Class Bongaigaon. Full stop. On institution of Miss Case number so and so, notice was sent to the petitioner for his appearance. Full stop. Para. Upon receipt of notice, comma, the petitioner approached trial court question is judicial magistrate, trial court by a petition, by an application, by petition, comma, petition number 367/2024 on 22/11/2024, seeking dismissal of Miss Case number 41/2024. Full stop. The prime contention raised by the petitioner in petition number 367/2024 is that the petitioner, the first party in Miss Case number 41/2024 has made the DNA report collected during the course of investigation of so and so case number equal line to as the basis of her application seeking maintenance. Post up. The petitioner has pointed out that the said DNA report is a part of the case records of Sessions case number 28/2024.
Twenty-six.
26. Huh? 26 of stroke 2024. The trial of which till then had not commenced. Poster. It was merely on the basis of the positive DNA report, test report. The application for interim maintenance had been filed. Poster. As the question of legality, validity, and acceptability of the DNA report had not been gone into by the Court of Sessions in the Sessions case number 26/2024, comma, the application submitted by the first party in Miss Case number 41/2024 lacked merit, and the application seeking maintenance was liable to be dismissed and rejected in limine. Full stop. Para. The trial court heard the parties on petition number 367/2024. Full stop. The trial court considered the provisions contained in section 125 within bracket B, comma, Code of Criminal Procedure, within bracket presently, comma, 144, one B. To observe that there is provision for maintenance, to provide maintenance to any legitimate or illegitimate minor child, whether married or not, comma, unable to maintain itself. First of the trial court has also relied in a decision of the Honorable Supreme Court in Sumitra Devi, page 33, versus Bikan Chaudhary, comma, 1985, 1 SSC 637, comma, wherein it is held that if the fact of marriage is discarded under section 125 CRPC, even if then also an illegitimate minor child is entitled to maintenance. Full stop. Para. The trial court has further observed that paternity is a very relevant aspect to be established so as to enable the court to direct the second party to pay maintenance in favor of an illegitimate minor child allegedly fathered by the second party. Full stop. Taking note of the fact that there is a DNA report in existence confirming the paternity of the second party in respect of the child born.
397 and 506.
Yes.
And subsequently 395 added, Lordship.
Okay. And how many?
20 persons, Lordship.
20 persons.
Lordship.
Charge sheet is received. 20%. This is CGM Borpeta.
Lordship.
Okay, then you are Mr.
Saddam Hussain, Lordship. Page
Saddam
68,
Hussain.
Lordship. Page 68, Lordship. Impugn order, Lordship.
1 minute. Saddam Hussain.
Saddam Hussain, Lordship.
Then after receipt of charge sheet, at that time you were in judicial custody.
No, Lordship. I am
Huh?
outside, Lordship.
Huh? Come to page 21.
21. No, Lordship. There is two Saddam, Lordship.
Huh?
One is Lordship, son of Ainul, Lordship.
Oh, you are the absconder.
Lordship. My father's name is Ainul Haq, Lordship. He is
Are
different,
showing as absconder in the charge sheet.
Lordship.
That man.
Lordship. In third paragraph, Lordship.
Seen petition. Thereafter, what happened? Charge sheet is passed. Considering nature, limit to reject the instant bill petition. Asia Khatun, seen the
Page
order.
68, Lordship. Paragraph 5, Lordship.
District Court.
Summon was issued to them, Lordship.
Hmm? When is the summon? You should summon to accused person, Saddam. Summon. This petition is for what? NBWA.
NBW, Lordship. Issued on Lordship 20/07/2024. Page 68.
Page?
68, Lordship.
All this while only summons. Only all this time prior to that,
Lordship.
only summons or what?
Only summons, Lordship. Para 5, Lordship.
Page,
Page 68, Lordship.
okay, I'm on it.
68. NBW issued, Lordship, without receiving the service report from the 68. 12 persons are already on bail, Lordship.
E8.
Annexure 3, Lord. Para 1, Lordship, there is 12 persons, Lordship, they are present and they are already on bail.
Your father?
Lordship, Ainul Haq. Para 5, Lordship. Relevant page 69. Lord. Saddam Hussain, son of Ainul Haq. NBW issued, Lordship, only on the ground that at the time of investigation they were absconding, Lordship.
No, this Saddam Hussein is what?
Ainul Haq, Lordship, page 69, Lordship. Son of Ainul Haq.
Ah, that was in 2024. Where are the subsequent orders?
Subsequent order, Lordship.
What might have flown much
Lordship, last order will find 10-6, Lordship, page
because
67.
there would be report.
Page 67, Lordship.
This is, I have reached up to 68.
Page 67.
Earlier orders are what?
10-6-2025, Lordship. Page 67, Lordship. For appearance, Lordship, fixed on, Lordship, it was fixed on 11/8/2025. Day after tomorrow, Lordship. The day before yesterday, Lordship. The menu to the option issue NBW against Alam Hundakar, Saddam Hussein, so and so.
Yes, you can keep it events for you to appear and apply.
Lordship में there is a bar, Lordship, section, Lordship, 232, Lordship. Kindly, Lordship, peruse to section 232, Lordship.
Then we have to call for LCR. To go into all these aspects, then we have to call for LCR. You be there, we'll examine that, whether he has correctly exercised the discretion or not, 232.
And without issuing, Lordship, bailable warrant, Lordship, directly issued NBW, and without receiving the report, service report, Lordship. Section 232, Lordship. If he
One
appears,
minute.
Lordship, he
1 minute. You also see section 90.
90, Lordship. Lordship, issue in lieu of any addition.
What are the summons? Let us see summons.
Summons issued on, Lordship, 6/3/2023, page 25. cognizance taken, and there on page 26, 11 page. Issue summons to accused persons.
So under 90 he can issue,
Issued, Lordship, but
right?
the petition.
And he has recorded reason. He has recorded reason, whatever. Some reason he has given. That is perfectly all right with section 90.
Lordship.
Because he has reason to believe. (232) there could be a bar. What to do? Others got benefited.
Others are already, only 6% absconding, Lordship. They are 14% already on
This
the.
will be guided by what is the new provisions for bail? What is the new provisions for bail nowadays?
480, Lordship, 480, Lordship.
480.
Lordship.
What are the sentence under section 290?
Lordship, 10 years.
Huh?
10 years, may extend to 10 years.
Maximum.
Lordship.
Then what is the bar?
232, Lordship, kindly.
232, yes. 232 has been interpreted. C232A, right?
Lordship.
They're subject to the provisions of this sonata relating to bail.
Lordship.
Subject to the provisions,
Relating to bail.
right? Relating to bail. B also.
Lordship.
Subject to the provisions of this sonata relating to bail,
Lordship.
right?
Lordship.
Remand him. But
Remand
that is, come to 480.
Lordship, remand the accused to custody until such commitment has been made.
Come to 480.
480.
480. You have said 10 years maximum.
Lordship, 10 years.
See, when any person accused of or suspected of commission of any non-bailable offense appears, you read appears,
Lordship.
before a court other than the High Court or the Court of Session, he may be released on bail, but such person shall not be so released if there appear reasonable ground for believing that he has been guilty of an offense punishable with death or imprisonment for life. So that court has the discretion to allow you on bail, subject to the provisions in bail.
Lordship.
Sir, that submission is not correct. That is why I asked you
Lordship.
that what is the maximum punishment.
10 years.
So NBWA is gone, meaning thereby the position is back to existence of summons.
Okay.
Then 437 earlier, now it is 480.
480.
That you have to argue to exercise the discretion.
Okay.
That has been interpreted that. So I can only say that you submit, you appear, he will appear and ready and willing to take part
May
in
I
the further
ask one
proceedings.
judgment, Lordship? One judgment, Lordship. Paragraph 10. There is for the second line. But in some parts of the country, there's.
Which one? Which paragraph?
Paragraph 10, Lordship.
10, I have read. Yes. I have read.
Lordship. Second line, Lordship, this is for the reason that in some parts of the country, there seems to be a practice followed by the courts to remand the accused to the custody the moment they appear in response to the summoning order.
209, earlier 209,
Okay.
right? That
Committee
has been
session.
interpreted by Supreme Court,
Lordship.
right? If it is imprisonment for death, imprisonment or death,
Not.
then that court has lacks jurisdiction.
Lordship.
But if it is not so, then that court has the jurisdiction to allow bail
Lordship.
upon appearance.
Lordship.
So you get that order, then we'll observe it.
Lordship.
We'll observe it.
Lordship.
Then it will be, you will be safe. But just because we do not set aside NBW order,
Lordship.
you get it. We put it on day after tomorrow.
Then Lordship may directly, NBW may be set aside and Lordship may
To
direct.
set aside is a difficult thing.
No.
See the provision. See the CRPC.
Lordship.
If there is some reason, how can we set aside?
Lordship, in this case, Lordship, without receiving any report,
Still has the power. I have shown you the order.
Lordship. But there is a
Provision.
procedure, Lordship.
We have to
Section
go
9,
carefully, sir. Just I wish I cannot set aside.
Lordship.
I have to find ways and means. It is not that
And the investigating officer.
you are so clean
Lordship.
that you will get the benefit of everything. No.
The
The
petitioner.
court has recorded reasons.
Lordship.
Satisfaction has been arrived at. I cannot go into his mind, and he has the power under Section 90.
Lordship.
If he has reason to believe, definitely this order cannot be set aside. Just if I wish.
Lordship.
Get that order 209 earlier Supreme Court interpreted. Get the order. We'll interpret. We'll observe that day after tomorrow. Right?
Monday, Lordship.
Monday. Okay. Monday. I should read. So that you are not under the apprehension that just because you appear, you will be automatically taken into custody.
Lordship.
I should list on Monday. Do you have that? Any idea? That interpretation, 209. Yes, sir.
Section 90 is clear.
90 is clear. That observation is
Yeah.
there. Right.
He is responding.
I cannot set aside it. Problem is that I cannot set aside it. He has given some reason. And 90 is clear. And that is to secure ends of justice, I can keep it in abeyance.
Right.
I cannot grant him bail, or I cannot direct the court to grant him bail. That is his discretion. That is a difficulty. It is not a ticket counter. You evade summons for 10 years, then you come.
Date of FIR lordship 1/12/22. Occurrence of 22.
It is not there. Okay, Monday. Okay,
90 close B lord.
209, section 209. Okay, on Monday.
Deeply obliged.
Come up with that 209, section
Lordship.
209 CIPC order.
Item 8.
Deeply obliged.
It is a challenge to a proceedings and the cognizance order under DVA. Initially, Lordship would find at page 12, a complaint was made against me and my sister and mother-in-law. Lordship would find that the complaint is vague. Like, except one, there is no specific instances, there is no injury report, there is no FIR. Now, cognizance is taken only against me. And
1,000 you are receiving.
My lord, only my lord, sometimes 5,000, my lord.
Who gives you 5,000?
5,000,
Second
my
wife?
lord. My lord, 2-3, my lord, this 5,000, my lord, for 2-3 months, my lord.
No, who gives you 5,000?
My lord, from-
Second wife?
My lord, no, my lord. My lord, that amount has been deducted from the pension of the second wife, my lord. The court has directed,
What is the total order? That is okay. Now let us see the
Lordship.
court order.
Court order, your lordship will
Read
find
court
the
order.
page 29 is a read court order, my lord.
Let us see once
Yes.
again.
There, my lord,
90
2,500,
minutes right. Okay, it is delivered order shall not be constituted the court.
that is the,
As if the court had declared the respective rights of either the petitioner or the respondent. Therefore, it would be open for both to approach the appropriate court to have their rights declared. Para 22.
Para, my lord, no, my lord.
Para 22.
29, my lord,
20,
29, my lord, from beginning your lordship will find, my lord. However, right of the petitioner to have her maintenance out of the said
Let
amount,
us read the total paragraph.
lordship, from page
Page
28,
29.
para 20.
In the present case in hand,
20.
right, also for husband have been able to demonstrate the husband has dominated.
Rational 7 is
That
the
is of
second
evidence.
wife.
However, the right of the petitioner to have her maintenance out of the said amount. But the decision interim order perhaps, see paragraph 22.
Lordship,
Paragraph 22. Same page 29.
29, madam. It is also clarified that the order shall not be in conflict with the court declare the respective right of either petitioner or respondent. Therefore, it would be open for the party to approach this honorable court having jurisdiction for their respective right declared. My lord, I have
Because nomination is only nomination,
nominee, my lord.
but right to
Right, my
get
lord. My
lion's share above 2,500. You have to have a declaration from the civil court that I am the first wife, so I nominee disburses the amount
my
only.
lord, that is right.
Right.
That is right, my lord.
So first wife has the right, being the first wife, above more, right? Let me see. Regulation contained herein would not preclude. So page 20, paragraph 23 also,
Not,
Yes.
right?
No, I have not approached the civil court, my lord.
specifically maintenance and
Then
or
also 24.
pensionary benefit.
Okay.
No.
So that right still remained. There you
Right,
can claim
my lord,
everything.
I have not approved the civil court. My lord,
Then
submission-
now let us see now the order.
my lord, initial order, your lordship kindly see, my lord. Initial order passed by MLA court, my lord. Page,
No, what is your prayer made now?
prayer, my lord.
What is page 31? File a petition. High Court order paying to issue direction to the governor to deduct an amount of so and so per month from the
31,
family
yes.
pension.
Pursuing this order, my lord, I am getting
Let me read.
my
So page 31 order 2,500.
2005.
Then you file petition or
My lord,
receive so and so, so and so. This issue direction to the branch manager to deduct a sum of serving so and so, so and so.
Yes,
And
2,500
received.
2011.
11, my lord.
But their
2011.
grievance is that from 2023 they are getting the amount. That
We are-
they are getting.
Yes, my lord. I am getting from 2023, not from
1
11.
minute.
Again, I filed an application.
When did he die?
My lord, he died, my lord, 2016, my lord.
16.
16, my lord.
Then you did not enforce at that point of time.
No, my lord.
It should have been, you should have enforced the order
No, my lord.
during his lifetime.
During lifetime, I got, my lord. I was.
Then
receiving, my
after
lord.
death.
After date, my lord, after date, there is a dispute regarding pension. That she is getting every pensionary benefit, family pension.
Then what is the order passed?
My lord, now the order has been passed, my lord. Your lordship kindly see page 35. 35.
Where from the branch manager will give?
My lord,
Problem lies there.
then the branch manager, my lord, my lord, I am getting, I am being paid on, my lord, account pay, my lord.
No.
My lord,
Where from the branch manager will give? Branch manager cannot give out of his own way.
no, my lord,
Area. Where from? Where from the amount? So,
my lord,
monthly pension, suppose 25,000 is
My lord. that from 20.
credited in the account. Out of that, you have got right 2,500.
2005.
He does not have any money. Branch manager.
My lord, since my lord, branch manager has been directed by the principal judge, my lord. Branch manager has been directed by principal judge. You, the branch manager, deduct
I think you
2,500.
should approach the read court.
My lord,
That this position, because of the litigation during the period from 2016, after the death of my husband, till this order, disposal of the writ petition, during that period, I did not receive 2,500, which
Yes.
was protected by family court order dated 2011. Now, see the position of the branch manager, where from he will give?
He can only deduct from the
He can
present month,
deduct 2,500.
only from present month.
No, my lord, my
Uh,
submission, my lord.
Mr. Manna, I could understand you have a right.
Yeah.
But where from this branch manager can give? He receives 25,000, say,
Yes.
credited in a bank account of that lady,
Let lady.
right? Second lady. He can have the power to deduct only 2,500.
Yes.
Right? He cannot take away everything from that. His mandate is only to the extent of 2,500. You should have got it clarified. You can file a miscase perhaps, I don't know. It is up to you. But this branch manager cannot take out this 3,63,150
My lord,
from the account of.
that is right, my lord.
And
That is
actually,
right,
you
my
should
lord.
have got, I don't know what legal advice you have got, but you should
My-
have gone for paragraph 22, 23, 24.
My submission, my lord.
I can
my-
only
my-
issue
my
notice,
submission, my
but
lord,
it is,
I-
it will be futile. I can only issue notice, but it will, end result, I
My
know.
lord, if you may, notice.
There is no light at the end of the tunnel.
My lord. My lord, if notice may be issued, my lord. He should come, my lord.
If the lady out of her own way gives it, that is a different thing.
Right.
Otherwise,
My lord, I. do
branch
not-
manager cannot.
My lord, exactly, my lord. My lord, my submission, my lord.
Okay, if the lady gives, then okay.
My lord.
Heard Mr. Manna Flannery, counsel for the petitioner.
Actually,
MP Goswami learned additional public prosecutor for the response number 2, State of Assam. Issue notice returnable in progress. As Mr. Goswami has appeared accepted response number 2, no formal notice. Extra copy, 22 working days, the petitioner shall take steps for service of notice on the response number 1 by registered post week. AD as well as by usual process, within 3 working days from today.
he should come, my lord.
Pressure tactics.
Item number
Only-
10,
Obviously,
Yeah, she is content with only 2,500. That is why.
No, this is a pressure tactic.
I seek only that amount.
This
my
is a
lord.
pressure petition.
Yes, sir.
No
Obviously,
legal petition. Next.
item 10.
এগুলো কমাই দিব হে সিটু
Please, Lordship.
Yes.
Lordship, I am allowed to withdraw this application, Lordship.
Okay.
Because, Lordship, the petitioner has been arrested
Oh,
after filing of this.
Mr. T. Thakuria, learned counsel for the
I can
petition
tell.
has submitted that in view of subsequent development, the subject matter of this criminal petition has become infractious.
Yes, Lord.
Full stop. Mr. MP Goswami, learned additional public prosecutor for the respondent state is in attendance in view of the above submission made by Mr. Thakuria. Learned counsel for the petitioner as regards the petition has become infractious, the petition is closed.
Most of
Item number 11,
Important.
My lord, limited prayer in this. case, my
Limited prayer.
lord. My lord, I'm challenging the order granting bail to the accused. my lord.
Limited prayer, big issue, huh? Yes.
Now, my lord, it is a POSCO case, my lord. The informant was not given a notice, my lord, prior to.
Which part, page?
My lord,
Seemed it.
seizure list, my lord, at
No, page,
15, my lord.
no. In the order 2/1/2025.
My lord, it is at 21, my lord. Relevant is,
This is 21 is regarding bail.
my lord, same, white same order, my lord. At relevant portion is page 24,
Page 24.
24, my lord. Same order,
Okay.
also seen the petition number.
Conduct
this.
is seal cover. What is the offense?
Offense, my lord, under section 13 and 10 of UPA Act, my lord. And my lord, It's
Is there any provision in the UAP Act for confiscation? Specific provision like NDPS? NDPS, there is a chapter.
yes, ma'am.
Get a report then.
Yes, on the. That is the.
Heart.
Order is at 125.
Mr. D.K. Medi, counsel for the petitioner, and Mr. M.P. Goswami, additional public prosecutor for the respondent state. Post of this criminal revision petition, a criminal petition. Should have been revision petition.
Hello?
It should have been revision petition
Hello.
because you are challenging an order of the trial court.
Yes, ma'am.
This petition is preferred. Agreed by an order dated 2/1/2025, passed by the Court of Sessions Judge, Unitpur, Tejpur, whereby the petitioner's application for interim custody of a motorcycle bearing registration number AS-12/T-7309 has been rejected. Full stop. The charge sheeted case,
No,
Not,
ma'am.
my lord.
No,
Ah.
ma'am.
the petitioner has claimed that he is the registered owner of the subject vehicle, huh? First off, issue notice returnable on so and so date. As Mr. Goswami appeared accepted. Extra copy within 2 working days. The Allied Additional Public Prosecutor shall obtain a report, press report
Yes.
from the IO of
It's good, yes, ma'am.
Tejpur
It's good,
Police
yes.
Station case number
It's good.
344/2024. As regards necessity or otherwise of the subject vehicle for the purpose of further investigation
10/9, 10 September.
and to place the same
With all respect.
on
my
the
lord,
returnable date.
Just, I want to just point out, my lord, I have some confusion regarding, Lordship has pointed out that whether it is criminal petition or revision, my lord. Some confusion regarding that, my lord, because in revision, my lord, interlocutory orders, revision is banned as per, my lord. for year
Subsection 2,
2, my lord. Whether
397
it will be
subsection
a
2.
interlocutory order or, because it has not conclusively determined the right, my lord. It has some confusion.
Okay, this
But-
cannot not
but,
required to be gone into at this stage.
Lordship.
Item 13,
15, my lord. Here also there is a rejection of custody
Same.
order, my lord, same nature, my lord. And
Same.
here the.
Which part? Cannabis, here NDPS.
Yes, but nothing was recovered from this vehicle and it is the husband of the petitioner who was arrested, my lord. And if your lordship will see the arrest memo, my lord. In the
Okay,
FIR,
same thing,
alleges.
same thing then.
Yeah, my lord.
DK Medhi.
Lordship.
Vehicle hull Maruti Suzuki being registration number
AA
AS01/ZE-6322. Rota Police Station case number 58/2025. Interim order, 01 order, 46/2025. Special Judge Udalguri. Same date, same.
item number 14,
Yes, the lordship. My lord, here lordship, the petitioner was released on bail on 5/8/2025 lordship. And at night around 9 PM lordship, I have visited the Chapur police station for taking my belongings lordship. Thereafter, I returned to Guwahati lordship. And around 3:30 lordship, I reached here and I take for few hours, I take rest lordship. Thereafter, I due to my unwellness lordship, I visited the Lordship Doctor's Clinic, Lordship. And in the meantime, Lordship, around 1 to 2 p.m., Lordship, my younger brother informed me that one notice under section 179 was sent
170?
179 of BNSS, Lordship.
BNSS.
Yes, Lordship. That was
very
sent.
familiar with 179.
There is paternity with
Let us
160
have,
of
let us
CRPC.
have a reading, then I can understand your submission.
At 12:20, that was sent, Lordship,
Any
directing
person
me
making
to
an
appear at 10 a.m.
investigation under the chapter may by order in writing, request arrest for any person.
Different second.
Yes,
So, my lord, here what happened, Lordship, at around 12:20, Lordship,
this is related to which provision of CRPC?
160 of CRPC, Lordship.
160 of CRPC.
160, Lordship.
Okay.
So, your Lordship may kindly see page 48, Lordship. Page 48, Lordship, that notice was, Lordship, scanned at 12:18 p.m. of 6/8, Lordship. And
Now,
sent
where is the bail order?
bail order, Lordship. That was, Lordship, at page 27, Lordship. Starts from
Bail
27.
order. It was on which date?
On 5/8, Lordship.
5/8. Where it is reflected? Because so many things have been written here. Krishna Iyer has been quoted
Lordship,
right at the very beginning.
Lordship, page 31, Lordship, that release order, Lordship, that my bail bond was accepted. Page 31, Lordship,
Page 30.
5/8/2025.
Huh.
5/8/2025, I was released, Lordship.
Huh.
So,
And previous order is dated?
on same day, Lordship, 5/8,
Same
but
day,
the
same
date
day.
was
Okay.
not mentioned in the.
Okay. Then?
Then, Lordship, I came to my residence at Guwahati, Lordship. And after, Lordship, visiting the Chapur.
You are resident of Guwahati.
I am the resident of Guwahati, Hathigao area, Lordship. So it would definitely take 6 to 8 hours, Lordship.
Hmm.
Then I reached around 3:30 a.m. of 6/8, Lordship.
6/8. Okay.
6/8, Lordship.
This page 47 is what?
Page 47 is the notice, Lordship, which was sent through WhatsApp to my younger brother.
Yes, Mr. Goswami, or proceed.
My lord, the only thing is that if he cannot appear, he could have informed the police that day itself, my lord. He has not informed the police.
My
There
lord,
is no bar, my
No,
lord.
it
This
is
a difficult-
WhatsApp. 47 is WhatsApp.
WhatsApp.
Have you examined this judgment in Satendra Kumar?
Satendra Kumar until on 16th May.
My lord.
Satendra Kumar until Satendra or Satendra?
Satendra Kumar until.
You order in writing.
I know.
I think order in writing. আছে নেকি? এইটো নহয়, এটা সৰু আছে, মই চোৱা নাই। 179. This is under 179.
179.
What is the heading?
But well, in fact, recently I have got one judgment, but I could not recall exactly that has been held that by WhatsApp it is not permissible. my lord.
Satendra Kumar until only.
No, my recently that's
That is
one way.
subsequent to big one.
Yes, madam. Subsequent to big one.
Orders passed in various IAs.
Yes, madam.
I have not read it, but I
Just 10
know
days back,
that
perhaps, madam.
On
few
16th
some
May
this
20.
41A, 41 CRPC notice cannot be served through WhatsApp.
Yes.
I don't know the other one, but here the heading is, see the heading.
One 179.
Heading. Yes, one.
Oh, yes. Heading of
Police officers power to request.
yes. Attendance of witness.
He is an accused.
He is an accused.
Previous day, I was taken into custody as
Yes,
an
please.
accused.
So his case is different.
This case is different.
First, you inform this IO not to take any coercive action verbally.
My lord,
Otherwise, I'll haul him up.
my lord.
Let him take instructions on this. In the meantime, you go through Potendra Kumar until.
But I have visited Lordship on 16 May 2025, that
Ah.
order was passed.
By order in writing, any police officer making an investigation under the chapter may, by order in writing, require the attendance before him any person within the limits of his own so and so, so and so. So he is an accused,
He's an accused, not a
and this
witness.
provision is for witness.
Witness. Yes,
This may be a case of harassment.
my lord,
You call him.
my lord.
Maybe he can, he has to join the investigation. That does not mean that and let us see the bail condition.
Bail order is not enforced.
Nothing.
Enforced.
No condition has been incorporated, right? Now, how can he give direction in page 47? You are directed to comply with the following directions. He will appear before the court as and when, as if he is the court.
My lord,
Something has gone wrong, perhaps. Inform this about this to the director of prosecution.
my lord.
Something has gone wrong. Is it not?
It seems, my lord.
He is directing. I have the case. APS. Take instruction on it.
My lord.
No coercive action. Heard, till it, next date. Heard Mr. N.A. Borvia, N.H. Borvia. Learned counsel for the petitioner, and Mr. R.R. Kosik, learned additional public prosecutor for the respondent state. First up, the petitioner has approached this court, agreed by a notice under section 179 BNSS, served upon him on
On 6/8
through WhatsApp
at 12:20 Lordship, that was sent.
at 12:20
20 PM Lordship,
PM.
directing to appear at 10 AM on the same day Lordship. That means I have to travel time Lordship,
Beyond time.
beyond time Lordship.
You see the movie Back to the Future. 12:28 PM on
12:20
6/8/2025 through WhatsApp,
Yes, Lordship.
whereby the petition was directed to appear before the IO of Sapor Police Station case number 119/2025 at 10 AM on 6/8/2025. Post op. A perusal of the notice, on perusal of the contents of the notice, annexed as Annexure 7 to this petition, it is found that the IO of the case has also made some directions to the notices, that is the petitioner. Post op. The petitioner has submitted that the petitioner is an accused in connection with Sapor Police Station case number so and so, and was arrested during the course of investigation of the said case. Post op. On an application file, the petitioner was granted bail in connection with Sapor Police Station so and so by the Court of London Judicial Magistrate First Class Bilasi Para on 5/8/2025. Post op. Having post op, Mr. Kosik, learned additional public prosecutor, has submitted that he will obtain instruction in the matter. Post op. As the petitioner is an accused in Sapur police station case number so and so, who has been released on bail on 5/8/2025, and the provision contained in section 179B and SS are privacy applicable to an witness, comma, there shall not be any coercive action against the petitioner till the next date of listing. In terms of the notice dated 6/8/6 notice, no impugned notice, and excess 7 till the next date of listing question, or list the case on next Thursday. Get proper instruction.
Matter some correction is required, typographical error, the petition was.
Okay.
I may be allowed.
Legal
Alright.
opinion? Okay, Mr. As on, as paid for, Mr. Borvian, the petition is permitted to make the inadvertent typographical errors kept in the petition before the register judicial within 2 days from today.
21/8. Item 15.
My lord, here in this case, short point is.
Yes, please.
Whether after the cause of action of a defamation case arose after acquittal or at the time of the defamatory statement or complaint.
1 minute, 1 minute.
My lord, whether the cause. of
You are Ruposi Sanda. Yes,
Yes.
what happened?
I filed a Azahar in the year 2015. The opposite party number 2, respondent number 2 was arrested, and then in 2024, he was acquitted.
Share business, no? 2024. Okay.
Acquitted. Now, after acquittal, he filed a defamation case,
Complaint.
complaint under section 500,
Original 500.
original,
Okay.
because it was filed in after acquittal. So whether cause of action of this 468 is barred or not?
Okay. Do you have any answer?
Yes, there is barred.
Barred.
AR 1978 ARSC 986. Oh. Paragraph 6 and 8.
1 minute.
Para 6 and para 8.
Para 6 and para 8.
The High Court ignored the bar of limitation on the ground that cause of action or proceeding for defamation could not arise before respondent was acquitted by the Court of Session. As the respondent was acquitted on 1st April 1975, it appears that the High Court took a view that the protection under section 468C was not available to the appellant. We are constrained to say that the question of cause of action could not really arise in this case, as the controversy relates to commission of an offense, as has been stated, subsection so and so of the code specifically provides that the period of limitation prescribed in section 468 in relates to an offense. Offender shall commence on the date of the offense. It would therefore follow that the date of offense was March 15, 1972, when defamatory complaint was filed in the court of magistrate. And that was the starting point for the purpose of calculating 3 years period of limitation. The High Court clearly erred in taking a contrary view. Then paragraph 8.
Yes.
It would thus appear that appellant was entitled to the benefit under subsection 1 of section 468, which prohibit every court from taking cognizance of an offense categorically specified in subsection.
Here,
two.
appellant is the accused in the complaint case. In this case,
Yes.
appellant was the accused.
No. Here in this case.
No, here in this
Yes,
Supreme
yes,
Court case.
yes, yes.
Okay.
Here also,
Okay.
in my case also, petitioner is the.
Yes,
My lord, although we are a formal party, my lord,
Hard.
one thing, my lord, just I want to point it out. And the complaint, my lord,
also violation of 223.
23, that cognizance.
Had Mr. S.K. Ghosh, learned counsel for the petitioner, and Mr. R.R. Kaushik, learned additional public prosecutor for the respondent number 1, state of Assam, full stop. Para. The petitioner herein had previously lodged a complaint before the court of subdivisional judicial magistrate, Hujai.
My lord, not petition.
Original?
Original, original was at page, annexure 2, page 17, I filed.
Now, what is this then? This page 13?
Page 13 now, the opposite party number.
This is Poddar. Okay.
For that.
Okay. Had earlier lodged the first information report before the officer in charge. Seizure police station.
Rangirkhari.
Oh.
Okay.
True. The in charge Rangirkhari TOP on 27/8/2015. Against the respondent number 2 hearing as the accused, and the CDFI was registered as Seizure Police Station case number 2346/2015 under sections 365/354 capital D of the Indian Penal Code. First up, after investigation, the case was charge sheeted against the respondent number 2 for the offences under section 366/511/354 capital D, IPC. Full stop. In the consequent trials, before the Court of Assistant Sessions Judge number 1, Kachar at Silsor, in the form of Sessions case number 91/2019, the respondent number 2 as the accused faced the trial. Full stop. After conclusion of the trial, the court of learned so and so by its judgment and order dated 17/6/2023 had acquitted the accused from the charges under section 366, 511, 354D IPC on benefit of doubt. Full stop. Para. Subsequent to that, Mr. Quashing, that will not come to page 43. It was May 2024.
CRPC will come.
So CRPC will.
That I was looking
My
at.
lord,
now.
CRPC.
CRPC will come.
So that round
That
is not
222 will not come here.
after his acquittal, comma, the respondent two has instituted a complaint
Page 13.
before the court of
Subdivisional judicial.
judicial magistrate
Ojai.
Ojai against the petitioner, alleging that the petitioner had defamed him in his society by submitting a false FIR regarding kidnapping in the year 2015. On to 2017, 2015. Post up. The trial court, the trial court, after recording initial deposition of the respondent number 2 as the complainant under section 200 CRPC and examination of witnesses under section 202 CRPC, comma, has taken, has found sufficient ground for proceeding against the petitioner for the offenses under sections 500/501, IPC, and by an order dated 10/4/2025, has ordered for issuance of summons to the petitioner, posting the next date of the case on 6/6/2025 for the appearance of the petitioner. Post up. Mr. Ghosh, learned counsel for the petitioner, has submitted that the proceedings of complaint case number, the complaint has been registered as CR case number 85/2022. Submitted that in view of the provisions contained in section 468 small c CRPC, the proceedings instituted by the respondent number 2 as the complainant in the form of complaint case number, CR case number 85/2024 is time barred. Time barred.
Proceed. One thing, my lord. Here, page 13.
Yes.
It's initial start, my lord.
Hmm?
Fourth column, my lord.
Page 30.
13, 1-3.
1-3.
1-3, the complaint, my lord.
Uh-huh.
The cause of action last date is 17/9/2023.
What is that? Why that is relevant?
My lord,
With 7, not 79 actually, it should be 17/6. Date of acquittal. And that is on benefit of doubt, not clean acquittal.
my lord,
That is another issue.
yes, my lord.
Right.
Because here in complaint
Issue
also
notice
he has
returnable in 4 weeks. Having regard to the materials on record, having regard to the fact that respondent number 2 was acquitted from the charges by the judgment dated so and so on benefit of doubt, and the provisions contained in section 468 C CRPC, this court is of the considered view that the petition has made out a prima facie case for interim relief, so accordingly it is ordered, in the interim, that further proceedings of so-and-so case number presently pending before the court of so-and-so shall remain suspended till the returnable date.
My lord, I'll take steps on respondent number two.
Text actually লিখি দিব কৌশিক respond number 1 আৰু Texas registered post usual process 3 working days.
Much.
Item 16.
May I please see?
Yes.
The whole case, my lord, of the year 2007, my lord. Petitioner before this honorable court, he was,
2007.
yes, my lord.
PRC number is only 2005 to 25.
Yes, my lord. But as FIR was, my lord, of the year 2007. In this case, my lord, my lord, petitioner is the president of the Komotapur, my lord, Akrasu, my lord, all Assam Coast Rajbangshi Students Union. Page, my lord, 14, my lord.
Page 14.
Yes, my lord.
FIR.
FIR, my lord.
Huh.
It set on fire, my lord, one bus, my lord.
Public property.
Yes, my lord.
PDPP.
Bond call was there, my
Then
lord.
person died. Person died also.
He died also, one died, my lord. But
Okay.
as he was the president, my lord, subsequently in the year
Then
2020,
succeeded.
succeeded 23, my lord. 11, my lord, IO was there, my lord. Were there.
Then
My lord, 47 my lord, pursuant to the notice, my lord, someone, petitioner appeared, my lord, also, my lord.
who is that?
Yes, my lord. Petitioner, my lord, actually took step, page, annexure 3, page 45.
That is not appearance in real sense.
No, he will appear, my lord. He will appear.
Now let us see on finding.
Annexure 3, page
Issue
45.
summons.
Yes, my lord.
Summons.
Subsequently,
Issue
my lord,
summons. Issue summons.
Summon.
Issue summons. Issue summons. Issue summons.
27 to 25.
So showing cause absent. Someone issued. Issue phrase. Issue and showing cause. Visually. Showing cause. Allowed. Someone issued. Showing cause. Showing cause.
Yes, my lord. Last page, my lord, it is accused Biswajit Roy, Kartik so-and-so, are absent with step, hide petition number, so-and-so.
So why you are here?
My, is that, my lord, he petitioner will, my lord, appear, my lord, on.
Law will take its own course.
Yes, my lord, but in the event of his prayer, my lord,
Then file anticipatory bail application if it is maintainable.
in accordance with law, it will be considered.
You have no cause of action.
No NBW against him also.
No cause of action. Show me the law.
That is not.
No law.
Well, just.
No maintainable, not
appearance on
maintainable.
Section, there is no direct involvement of the.
Section 90
Proceed.
is there.
Yes, 90.
Magistrate sees reason to believe, then only he will, normally it is summons. Now, after that, he has no power or power, that is a different issue, but otherwise.
There is no specific allegation also.
That will not go.
Yes, my lord.
You are seeking quashing or you are, what you are?
Stay of the proceeding, my lord, quashing, my lord.
Quashing, on what ground?
It is an old case, my lord.
Old case.
Yes, my lord, there is no.
Argue your ground, argue your ground.
Yes, my lord.
Argue your ground for quashing.
Page 8 grounds, my lord.
Page 8. Let me see your prayer first. Shall not be set aside. Recall order dated so and so. Okay. Page 8.
Yes.
Why not enable FIR, search it? FIR, if it reveals cognizable offense,
Yes, sir.
Definitely. And why subsidy is not maintainable? And proceedings?
Because my lord, after 16 years.
Parrot, ground 3
Yes,
is wrong completely.
but it is not.
Absolutely wrong, copy paste. Absolutely wrong. You said warrant of arrest has been issued,
No, no,
whereas the
that-
court issued
absolutely.
only summon. 16 number, no specific involvement. We don't know without looking at it. Ground 4.
Yes.
And registered as so and so, SASE filed on so and so, are not at all consonant with the alleged offense. Don't know. Then ground 6. Bailable warrant. Where bailable? Ground 6 again. Wrong. Absolutely wrong. Almost all serious offenses.
No copy of inquiry report, postmortem, inquest report, etc.
That will be given only at the stage of 207, sir. When you appear.
Yes, my lord.
Huh?
He will appear, my lord, only next day, 28.
You appear, there is nothing.
In accordance with
There is
the-
absolutely nothing.
No, my lord, he will appear, my lord, but as he
Wrong grounds.
no, no,
Bailable warrant,
Several
non-bailable warrant. When the court
several sections are serious sections are there, my
Serious.
lord.
Serious.
He has apprehension. my
person
lord.
has died, serious.
Yes, my lord. His apprehension is that though he directly, as he was not directly involved, he was the leader.
That
my
we
lord.
don't know. He has been charged
No,
with
my
it.
lord, in the event of his, my lord, he appearance, my lord, his prayer for bail application may be considered in accordance with law, not for, I am not praying for allowing him to go on.
That will
bail.
obviously be considered as part of.
Obviously,
Yes, my
will
lord.
be
Only this
considered.
much, my lord, I prayer, my lord.
Huh?
Only this much prayer, because my lord, otherwise I cannot pray more than that, my lord, at this stage. 28/8/25 for appearance. Planet code below judicial magistrate first class is taking up this.
But I will record that there is no cause of action for the petitioner to prefer this petition.
Yes, yes, my lord.
Be that as it may.
Yes.
Heard Mr. H. Das. Is it a license? Mr. Das, is it a license?
No, no, my lord.
To
That's my lord.
heard
Planet
Mr.
code
H.
below
Das,
observe
Planet
that.
counsel for the petitioner. And Mr. R. Kosiklan, additional public prosecutor for the respondent state. The petitioner has prepared the instant petition, criminal petition under section 528 B and SS, seeking to invoke the inherent powers of this court by selling two orders dated, dated 27 to 2025 and dated 2/5/2025, passed by the Court of Learned Judicial Magistrate First Class Thubri Trial Court in the course of the proceedings of PRC number, police station, police report case, within bracket PRC number 1713/2025. Full stop. From the materials on record, it has emerged that an first information report was lodged in connection with an incident occurred on 27/10/2007 within the territorial jurisdiction of Golongganj Police Station. In the affair, 16 number of persons were named as accused, including the present petitioner as accused number 1. The said affair was registered as Golokganj Police Station, case number 579/2007 for the offences under section 147, 148, 149, 341, 436, 326, 307 IPC, read with section 4, prevention of damages of public property, PDPP Act, post of subsequently, section 302 IPC has been was added on 18/11/2007. Post of upon investigation, a charge sheet was submitted. After more than 15 years, by charge sheet number 132/2023 on 30/3/2023. In the charge sheet, how many were charge sheeted?
16.
16 persons were charge sheeted, have been charge sheeted, and the petitioner is one of them. Post of the charge sheet was submitted, has been submitted, finding prima facie case for the offences under section 148, 149, 341, 440, 326, 307, 302, IPC, read with section 4 PDPP Act. Post of on receipt of on submission of charge sheet, the case has been registered as ERC number 1713 of 2023. And the trial court, our trial court taking cognizance, issued summons to the accused persons by an order dated 10/1/2024. Post of as on receipt of the summon, the petitioner through his engaged counsel preferred a petition showing cause for his absence on 27/2/2025. Post of similar petition was also filed on behalf of the petitioner on 2/5/2025. Post of by both the orders, the trial court allowed the petition, fixing next dates for appearance of the petitioner. Post of the next date for appearance of the petitioner is on 28/8/2025. Post of after hearing the learned counsel for the parties at some length, Mr. Das, learned counsel for the petition, has submitted that the petitioner is ready and willing to participate in the proceedings of ERC number 1713/2025 by appearing in person on 28/8/2025. Post of he has further submitted that if on such appearance, the petition with such appearance, the petition also intends to file an application seeking his release on bail. Post of he is limited. He has made a limited prayer to the effect that in the event the petitioner appears and submits an application seeking his release on bail before the trial court on 2/8/2025, the same shall be considered in accordance with law and its own merit. Post of having gone through the materials on record, comma, this court has not found any cause of action for the petitioner to seek setting aside and quashing of the proceedings of PRC case number so and so at this stage. So be that as it may, comma, as the petitioner, as the counsel for the petition has made a limited prayer to the extent mentioned above, comma, it is observed that in the event the petitioner appears before the trial court on the next date of hearing, comma, 28/8/2025, which is fixed for appearance of the petitioner, and so, prefers any application for bail, the trial court shall consider the such application on its own merits in accordance with law. The instant criminal petition is disposed of. With the above observation, the criminal petition is disposed of. Accordingly.
Item number 17.
There is no representation on behalf of the petition to the uncalled. Is the case on next to the deduct Thursday.
Item 18.
Eighteen and 19, your lordship, arising out of the same case, your lordship.
Okay.
Same.
What is the case about?
18 and 19. This is against your lordship rejection of our petition for your lordship custody of certain materials, your lordship goods, your lordship.
What are the materials?
Your lordship will kindly get it at Annexer A, your lordship.
Annexer?
Annexer 1 and 2, your lordship. 16, your lordship may kindly see. First starts from your lordship, Annexer, page 14, Annexer 1. Materials in the prior portion, your lordship, we have specifically mentioned the goods.
Page 14.
Page 14 is the seizure list, your lordship. These are the materials, and your lordship will specifically get it at you in my prayer, your lordship. Page 12. I have mentioned the material. One mobile handset. And in fact, your lordship, petitioner here in your lordship in item number 18, he is not an accused in the case, your lordship.
Okay. Where is the Interim order?
Lordship will get it at your lordship. Page 100.
86, page
Page 86, your lordship. Common order, your lordship. This is the first part is relating to petition 18, petitioner in item 18. Petition number so and so 497-503 BNSS dated 16/5/2025 filed by the petitioner C. Omlan Bora, supported by an affidavit praying for giving Zimma of one mobile handset make Samsung model Galaxy S22 Ultra bearing IMEI seal.
Case is related to what? What is BUDS Act?
BATSEC, your lordship. BATSEC, your lordship, that's a
banned unregulated
unregulated
deposit. Banned unregulated deposit is
banning of unregulated deposit scheme act 2019, your lordship. Under section 7, your lordship. Your lordship will kindly come to page 91, the finding of the there's second paragraph, Prince Kumar Gupta, Sub-Inspector Police, CBI, New Delhi has filed a written objection through Naveen Giri, learned PP for CBI, stating inter alia that the investigation of the case is still going on and the said articles are necessary for further investigation of the case. It is also stated that item mentioned at serial number 9 is not under their custody.
Then your lordship, I have already heard the learned advocates of both sides. Peruse the case record, case diary, including the charge sheet carefully. Upon perusal of the case record, it is seen that IO has submitted charge sheet being number so and so, dated so and so under 3162, 3184, 3165, 612, and 238 of BNS 2023 and section 21.1, 21.2, 21.3, 23 of BATSEC 2019 against 4 accused persons, including the Zimma petitioner, that's Tapan Bora.
What is the disorder, page 93?
Page 93 is your lordship. This is by your lordship some other person, Bisal Fukan, not related to us. But we have annexed it, your lordship.
Okay, we'll issue notice. and
Lots.
We need some time to file reply. This,
Yeah, will you reply?
this is investigated by the Delhi branch. At least 3 weeks' time may kindly be granted. Because maybe mobile and laptop has been sent for forensic for retrieving the datas.
Okay,
And still investigation is going on. It is a investigation is going on Odisha, Bengal, Dibrugarh, Delhi, Ranchi.
Maybe your lordship, I am not even an accused, your lordship. So no search sheet, nothing, your lordship, there, your lordship, on the ground of further investigation, can they keep this
But
materials?
those are sent for forensic, for retrieving the datas.
okay, you identify
Sir,
which
let-
are
let
sent
the-
for
I will
forensic,
give reply, your lordship.
whether retrieval of data is complete or not. Answer on the next date.
3 weeks' time may kindly be granted.
Heard Mr. S. Borthakur. Land counsel for the petitioner. And Miss M. Kumari. Land standing counsel. CBI for the respondent CBI. Post up. The instant petition is preferred. A sealing an order dated 18/7/2025. Passed by the Court of Learned Special Judge
19 of-
CBI Assam
Item 19.
in connection with RC number page 86. Whereby the petitioners pay for interim custody of the items mentioned therein has been rejected. First up, issue notice returnable on so and so date. As Miss Kumari, right, so and so has appeared and accepted notice on behalf of the respondent CBI. Issuance of formal notice is dispensed with. Extra copy within 2 working days. As Ms. Kumari, standing counsel CBI has sought for and is granted 3 weeks time to file its reply as regards the claim for custody made by the petitioner in respect of the items. First off, it is submitted that by Ms. Kumari that the items involved herein are sent for what retrieval of the data.
That I am still not aware. Maybe these are seized.
Might have-
one
might
of
have-
the
might have been
seized,
sent.
It's a IO. is
Might
the
have been
complete-
sent for retrieval of datas. Full stop. If the items are so sent, the present status of the retrieval process shall also be mentioned in its reply.
Process, if any, may kindly.
Might, I have said might.
Much
In
obliged.
fact, your lordship, in 19, your lordship will kindly see the prayer portion, your lordship. Drone cameras, your lordship, drones, your lordship, that I use, I am a photographer, your lordship.
Okay,
They have, your lordship, kept this, your lordship, with them, your lordship. What purpose there, that is not required for.
where is
Your
the,
lordship will kindly see page, page 13, your lordship.
no, where is the interim order? Oh, sorry, impugn order.
Your lordship will get it at
Page,
page, your lordship, 91, your lordship.
okay. How many petitioners?
One petition, right?
One. Same then, returnable same.
Lord. Your
These are
lordship,
drone camera.
And a mobile laptop is also there.
Laptop
is there?
Yes.
but
Okay, some
I am
of
only-
some of the items
lordship,
might be sent.
Electronic gadgets are.
Retrieval.
lordship, can it
Laptop is
be-
here.
Yes, your.
Laptop is involved.
Laptop is involved. Laptop is there, your lordship, hard disk is there, but we are more
Hard disk
concerned with
is
your
also
lordship,
there.
these cameras, your
Okay.
lordship, because that's the only source of livelihood for me.
How many?
Your lordship, around your lordship, at one number of drone, your lordship, and 3 numbers of batteries, your lordship. Drone,
So if the drone has any memory, you can take out that memory.
So IO will give appropriate reply then.
lordship, can it be on 5th, your lordship?
Fine.
Lordship,
Acha.
deeply open.
Item 20.
Yes,
May I
sir.
please, Lordship? Lordship, in this case, application for quashing of the FIR, Lordship.
Crossing of affair. Let us see the affair then.
Page number 19, Lordship.
19. Vernacular is in 19. Okay.
Assamese version is 19.
Gulzar Hussain. You are
I am
Mukajul.
Lordship,
Mukajul and
woman also is the petitioner in this case, Lordship.
Huh?
Petitioner
Let us see first the affair. It was lodged on 11. Okay, English. Tarikh Rati Begum May 2009. Okay, there is one more.
Allegation is Prosecution, Lordship. Petitioner, informant and accuser jointly prefer this application, Lordship. For question, they have just settled amicably between the parties, Lordship.
How can this be settled, sir?
The family members are there.
Maybe. Show me this kind of offense can be settled.
So this is the judgment.
Because prosecution is taken over by Norinder is not
Yes,
applicable. Which paragraph?
29.1.
29, which part?
29.1.1 and 29.2.
Show me any of this.
This is our High Court or
Any of this paragraph is relevant for an offense of this nature. This has gone up to maximum 307.
settlement on the basis of petitioner quashing.
This is not matrimonial, not commercial. And so far as IPC offenses, it has gone up to maximum 307. Norinder. Show me any other. This is not applicable, sir. Norinder is not applicable. Norinder cannot be applied everywhere. This is a major lady, not minor.
Sometime request.
No offense. 376 is made out.
Or some other judgment here also, but at this moment I have.
Forward by Ahir applied. 417 basically. 417, which is itself is compoundable. We should notice nothing. Hard, Mr.
RL
Chutiel and Council Court of Take a look. And Mr. B. Sharma, Additional Public Prosecutor for the Respondent State.
Informant is not made a party.
Information the petitioner, the number two.
Oh. Mm.
Seeking quashing of criminal prosecution pertaining to Laurigat Police Station, case number 5/2025, registered under section 65, Union Bracket 1, Bharatiya Nyaya Sanhita, read with section 6, Protection of Children from Sexual Offences Act. The instant criminal petition is filed on the ground that the informant, who is the father, who is the father of the minor victim and the petitioner, has arrived at an amicable settlement, executing an affidavit on 21/7/2015. Issue notice returnable on so and so date as Mr. Sharma has appeared. Petitioners, huh? Then petition number 1, okay. Sharma, extra copy, 3 of index.
Item 49.
Petition. Okay.
My please. My lord, in this case, my lord, we have silence, my lord, order dated 25/7/2025. My lord, that page
25/7.
Yes, my lord, page 55, my lord, yes. And accept 10.
Page 55, yes.
Yes, my lord.
Which order?
25/7/2025, my lord. My lord, by this order, my lord, the cross-examination of PWs have been closed, my lord. But on that day, my lord, I appeared and submitted petition, my lord. That is petition, my lord, page 53, my lord. I have an example of the petition, my lord.
Now, how many occasions you sought adjournment?
No, my lord.
Tell me.
Lord petitioner is my lord, serviceman, my lord.
Whatever, your counsel was there for help.
My lord, yes, my lord, I on every day.
Petition is present with
My lord, and file. the
absent
petition.
and sought adjournment showing cause of
My lord,
today.
page 46 from onwards, my lord, I have
page?
annex order, 46, my lord.
46.
Yes, my lord, the prior orders of, I have also annexed, my lord. On 21/3/2025.
It's 46.
46, yes, my lord. On 21/3, my lord, I have appeared and submitted my WS, my lord. Thereafter, the matter fixed for disclosure of assets and liabilities, my lord. Thereafter, my lord, fixed on 26/3/2025, my lord. Petitioner is present, opposite party is absent, and by petition number so and so made prayer for submission so and so, my lord. On that day, my lord, 800 rupees was cost imposed, my lord, which was also, my lord, paid, my lord. Thereafter, 7/4/2025, my lord, petitioner has made opposite party is absent, by petition number so seeking time for his appearance and submission of affidavit and disclosure and assets of liability. The prayer for submission of the aforesaid affidavit is rejected as the said prayer was granted as last chance today after grant of 2 adjournment for the aforesaid purpose. Fixed on so and so for evidence of petitioner witness.
Really good at console.
My lord, I have annexed all annexed, my lord, and every date, my lord.
Really good at console.
White order data 7/4/2025, my lord. Case was fixed for 7/5/2025. On that day, my lord, it was local holiday due to Panchayat election, my lord. Thereafter, the matter was taken up for, my lord, on 8/5/2025. On that day, I was absent, my lord, because I don't know, my lord, whether the case was fixed. Since the case was not fixed on 8/5/2025, my lord. Thereafter, on 28/5.
1 minute, sir, 1 minute. 1 minute. If it is family court,
Yes, my lord. Principal Justice, family court would be, my lord.
then it should be under Family Court Act.
My lord,
And first, you tell me, this is an interlocutory order or not interlocutory order? Because it is governed by section 19(4) of the Family Court Act, not under CRPC. Have you examined that?
my lord,
There is a bar. This is non-obstante clause. This is what? Maintenance.
my lord, maintenance.
See, maintenance, chapter 9, CRPC.
Before, my lord,
This is under section 19, subsection 4, Family Court Act. And first you satisfy me whether closure of this is not an interlocutory order. Otherwise, your family petition should have
by
been
this
structured
order-
under section 19(4), right? Of the Family Courts Act, not under BNSS. That is another question, whether it will be single bench or division bench, that is another matter. Otherwise, appeal or revision may be before division bench. Now, this closure of this occasion to cross-examine, right?
my lord, cross-examination.
How? Tell me, it is not an interlocutory order. It is interlocutory or not an interlocutory order?
My lord, it is final order, my lord. Since, my lord, by this order, my lord, I have been debarred from cross-examination, my lord. And if I will not,
Sir, have you understood the meaning of interlocutory order and final order? Final order is the maintenance order.
yes, my lord.
And other orders passed during the course of the proceedings
Yes, yes, my lord.
are generally interlocutory orders.
Yes,
Right?
my lord.
And there can be a third category, which is Honorable Supreme Court has termed as intermediate order.
My lord.
Right?
My lord.
Now, for any interlocutory order, no revision is maintained. Law is that. Now tell me this closure of the opportunity
My lord.
to cross-examine the prosecution witness
My lord.
is not an interlocutory order. If it is not an interlocutory order, your revision petition will be maintainable. So that is to be satisfied, point is to be satisfied. There may be thousands of cases, precedent. Show me something. And it is not that on the first day it was closed. So whether it is an interlocutory order or not an interlocutory order. If it is not an interlocutory order, revision is maintainable.
But let it be fixed on tomorrow, my lord.
Find out something.
Tomorrow. my lord.
Otherwise, and go to family court side. If it is family court order, then it is to be an revision under section 19(4), not under BNSS or CRBC. Because special act will prevail.
My lord, the petition is filed under section 144 CRBC.
Right. Still, chapter 9 of CRBC, it is clearly mentioned in family court act. And 125 or 144 comes
144.
under chapter 9. Okay, Friday, bondho nahi?
My lord, Friday.
Tomorrow we have a division match,
My
second
lord,
half.
otherwise, my lord, what happened, my lord, 19-8.
You make a prayer for adjournment. It is up to you. Otherwise, this petition is not maintainable under BNSS. It is not to be entertained. Secondly, whether you satisfy me, it is an interlocutory, not an interlocutory order. Charge framing is not an interlocutory order. That is what has been held in a case, criminal case. Because intermediate order is those if by one, if yes, it continues, but if no, say it terminates the proceeding, then it is interlocutory order. It is neither here nor there. Proceedings is not terminated, it continues.
Yes, my lord.
So, in all possibility, it is an interlocutory order. Yes, Mrs. Farmer.
But that question has to be, well, that question has to be, my lord, firstly satisfied, your lordship.
For every opportunity, you can jump to
Yes.
this court. Take your time. Tomorrow is not possible.
My lord, on 18.
Tuesday.
18.
Tuesday 19.
My lord, Tuesday is 19, my lord, so 18 maybe 18th.
Tuesday already 50, 60 matter, I don't know.
Hmm.
On the prayer of Mr. A. Hussain, I consider for the petitioner, release the case on Tuesday. Find out, satisfy me, it is not an interlocutory order. Because expressly it is barred. Yes,
May I please, your lordship?
please.
I filed the additional affidavit.
I don't know what is this. Petitioner, the civil dispute. Please tell me what is the case.
Yes, your lordship, I was required to file a charge sheet of the previous case.
How many petitioners here?
There are 23 petitioners now who have died. But in the complaint case, the CR case, there are 25.
Now, out of these petitioners, any dead persons are here?
I have not made them the petitioners.
Oh, good.
But for the understanding of the court, I have.
Good. So 23 petitioners here.
Yes, yes.
Okay. And what is the case about what you are seeking quashing of what?
I'm seeking quashing of the entire complaint case.
Okay. What is the genesis?
The genesis is your lordship, the respondent.
Complaint case?
Yes,
Complaint case?
yes, but it
What
is,
is the complaint?
the complaint is in page number 23 of
23.
the main petition.
23. It was
It is the
laws
translated-
before whom?
It was brought before the learned SDJMS Morigaon.
Okay, let us read the
May-
complaint.
May I please, your lordship? Just before
We'll
we
go to
the complaint-
antecedent facts later on.
Your lordship, may be kindly see page number 23. The second
Okay,
paragraph.
I'm reading. So there was a case registered on the basis of FIR lodged by this informant, complainant, right?
Yes.
Zagreb Police Station case number 15 of 2007. It was search-seated, ZR case number. Then there was a policy of the government for withdrawal of the prosecution.
Under section 321 of the CRPC.
321, and there is a policy also part
Yes,
of it.
yes, Your Lordship. There
So
was
it
a
was disposed of.
notification.
So on the basis that he has been deprived of justice, he has lodged this complaint.
Yes.
Right?
Yes.
This is the case.
This is the case.
So
Now, may I please, Your Lordship? Now, coming to the crux, Your Lordship, the charge sheet which was filed earlier under this GR number 111/2017, 19 numbers of accused persons who are the similar accused persons in the new complaint case, the fresh case, were not charge sheeted. They were not sent up for trial. Only 6 numbers of persons were sent up for trial. And
in
that is
the original
reason-
charge sheet,
Yes,
you
Your
want to say? Where is the original charge sheet?
I have filed an additional affidavit on that behalf, and charge sheet is on page number 53 of the additional affidavit, Your Lordship. But for the easiness of the court, I would like to bring the attention of the court to page number 5 of the additional affidavit. Paragraph number 4, I've clearly stated there. Sorry, page number 43, Your Lordship, of the additional affidavit. Apology. I've also drew
You
up a
want to
paper.
say which one? Page 43.
Page
okay.
43 of the additional affidavit.
I'm at page 43.
Yes, the paragraph.
There is a table.
Yes, Your Lordship.
Now left side table, persons not sent up for
Not
trial.
sent up for trial. There is 19 number of.
How
persons-
many were sent up for trial?
The 6 on page 44. Yes.
6.
Moreover, the investigating
Now,
authorities,
who are these petitioners? The other 19,
all the 23.
all the 23.
Yes, sir.
But they don't, these 5 may not have any cause of action. The
No.
rest 6.
Your Lordship.
But
they have a
19
case.
may have a case.
They also.
19 may have a case.
Yes, Your
But
Lordship.
these 3, they have unnecessarily added up here.
No.
They
Your
had a
Lordship.
case because state had undertaken the prosecution, right?
Yes.
And somehow or other, PP has withdrawn that case. But so far, these 6 are concerned. They may not have this because the complainant has a grievance, definitely.
May I please, Your Lordship, may I please be able to satisfy this?
Yes, Mr. Sharma.
It is better, all are, my lord, not in the same footing, my lord.
May not be,
May
but
not be, my lord.
the 19%
Yes.
are here out of 23.
Yes, my lord. They have some problem.
They have a grievance also.
May I please, Your Lordship?
When the case was filed? Complaint?
2023, Your Lordship. 31 March 2023.
Art, Mr. As to learned counsel for the petitions. Mr. D. Sharma, and additional public prosecutor for the responding number 1 from our state or some. Post of
I most humbly beg your pardon, Your Lordship. May I please be allowed to say something, please? A very factual point which has been mistaken here. The government has issued notification in the year 2022, and they have clearly mentioned there that the complainant, if his or her case is withdrawn, is at
Are
liberty.
you wanting for the court to do the final hearing today?
No, Your Lordship. I just want to bring the
Then,
crux of the story, Your Lordship.
when I have stopped you,
Obligatory. I beg your pardon.
you should know then. Unnecessary submission is not welcome. The submission you have made already is enough. The petitioners, 23 number have joined together to prefer an instant criminal petition under section 528 B and SS. Full stop. In this criminal petition, the petitioners have sought setting aside and quashing of criminal proceedings pertain to CR case number 258/2023, instituted by the respondent number 2 as the complainant. Full stop. The contention of the petitioner is that at an earlier point of time, the respondent number 2 as the informant lost the first information report on in the year 2017, and a said FIR was registered as Zagirot Police Station case number 15/2017. Full stop. In the said FIR, the respondent number 2 as informant named 25 persons as accused. Full stop. Upon investigation, the IO submitted a charge sheet in connection with Jagirot Police Station case number 15/2017, within bracket corresponding GR case number 111/2017, finding prima facie case against only 6 number of accused. Full stop. One or two, how many died? How many died now?
Two have.
Okay. Out of those 6 charge-sheeted accused persons, 2 have already expired. Full stop. The remaining 4 charge-sheeted accused persons are among the petitioners hearing. Full stop. Para. The proceedings of GR case number
Your Lordship,
111/2017 stood closed on withdrawal by the public prosecutor as per a policy of the state government. Full stop. It was after such withdrawal of GR case number 111/2017, the respondent number 2 as complainant instituted the proceedings of CR case number 258/2023. In the complaint, The respondent number 2, this complainant has arrayed 19 number of petitioners out of the present 23 petitioners as accused, whereas in the charge sheet filed in connection with GR case number so and so, they were not charge sheeted. Yes, any?
Your lordship, one from those 6 numbers have died and one from the other 19 numbers have died.
Okay, out of 5.
That is a minor rectification.
6 আছিল না তাৰ দুটা বুলি কৈছে এটা কৰিব হা আৰু remaining 5 are among the present petitions আৰু এইটো 19 to 5 18 কৰি দিম. Issue notice returnable in 4 weeks as Mr. Sharma has appeared accepted.
Most certainly pray for the stay of the operation till the next date, your lordship. This is a clear case of section 320.
Why you are
At least till the next date, your lordship.
Why you are interrupting? Let the order be closed. You have not understood my
Lordship, I
my
beg apology.
indication. Mr. Sharma has fully understood.
Lordship, I'm very new to the profession and it has happened to me twice back.
Don't be over enthusiastic.
Yes, Lord. Yes.
I have already stopped you once. Right? You will miss the bus otherwise.
Again, not, your lordship.
Yes, Mr. Sharma. Respond number 1. The petitioner shall take steps for service of notice upon the respond number 2 by registered post as well as by usual process within 3 working days from today. Having regard to the projections made above, as narrated briefly, it is ordered in the interim that further proceedings of so-and-so case number pending before the court of Subdivision Judicial Magistrate S. Morrigan shall remain suspended till the return.
Item 51.
May I please object? In this case, Lordship, I am challenging the impugn order dated 3/6/2025, whereby the learned court below had issued a non-bailable warrant of arrest against me. And the Lordship, the impugn order is page number 54, Lordship, Annexure 18. The Lordship, last occasion, Lordship directed me to submit the second page of the impugn order, Lordship. Because Lordship, at the time of the filing of the case, Lordship, the second page of the impugn order was left to be annexed. And the Lordship, I filed an affidavit, Lordship. Lordship, in this case, the so-called warrant was issued on the.
Let me read the order. Let
Yes.
me read the order. To submit his written statement, the written statement, no written statement was filed. As a result, the case proceeded for hearing, full stop, during the petitioner side, the opposite party, the respondent as opposite party, adduced evidence through 2 witnesses, including herself. Full stop. Though opportunities were there. The petitioner, sorry, to respondent, opposite party will close it as opposite party no one. Respondent wife. The opportunities were there, the petitioner did not avail the opportunity to cross-examine the witnesses of the respondent's wife. Poster. Para. Both the parties in support of their case had submitted affidavits of assets and liabilities. Poster. It was after hearing the learned counsel for the parties, learned family, the family court had delivered the judgment dated Swins. Post of Mr. Smedil and counsel for the petition has submitted that the amount determined by the family court as monthly maintenance is beyond the ways and means of the petitioner. Full stop. The petitioner is only an employee under a what is a cable operator, under a cable operator. First stop. Cable operator also provides DTH connection nowadays. One satellite, another, I have my own connection, which is provided by the cable operator. So business has not gone down.
Nowadays, cable operators is nothing.
No, I have my own home. I have two connections. One is satellite, one is cable. And we pay good amount,
Today's Dix.
500 per connection. Para Mr. Das, appearing for the respondent wife, has submitted that the assertion made by the respondent wife during the proceedings, during the maintenance proceedings, had gone unrebutted. Full stop. And her evidence on affidavit,
Yes.
evidence on
Yes.
affidavit, comma, the respondent's wife had asserted that the petitioner is a businessman dealing in telecommunication, cable network, business, etc., and earns rupees 50,000 per month. Full stop. No documentary evidence was, however, been adduced in respect of the business stroke income of the petitioner. Full stop. Para. Notwithstanding the above, comma, it has emerged that the petitioner has an educational qualification, of higher secondary living certificate examination pass. Post op. It has also emerged that the petitioner is an able-bodied person suffering from no physical disability. And is presently aged about 48 years of age. Full stop. Apart from his mother as a dependent, the petitioner has no other dependent. Full stop. Even it is assumed that the petitioner is an unskilled day labor, comma, as claimed by him. Having an income of rupees 7,000 per month, comma, as claimed by him, comma, this court finds no reason to interfere with the order, the direction given by the family court to pay an amount of rupees 3,000 as monthly maintenance to the respondent wife. Full stop. Considering the full stop, the petitioner being an able-bodied person has the obligation to pay maintenance amount to his respondent wife so that the respondent wife can have the basic necessities of life for living at least a respectable life. Full stop. The petitioner cannot shirk the responsibility and neglect to maintain the his wife, comma, who more particular for the reason that there is no evidence on record that the wife has any independent income. Full stop. Any matter of the view, any view of the matter, comma, in amount of rupees 3,000 by no stretch can be regarded as by no stretch can be regarded as a higher amount, considering present situation and cost of living index. Presently, this previous petition is found to be free of merit. Consequently, it is dismissed.
Highly opposed.
Above.
Item 23.
May I please, Your Lordship?
B. Islam,
Petitioner paying for crossing of.
MP Gustami adjournment, conducting measures on matters adjourned.
Here is the basic allegation in that, Lordship. The petitioner has not supplied any metal after receiving the advance amount of rupees 13,90,000.
What is a criminal petition?
Lordship,
You are seeking quashing of what kind of proceeding?
proceeding, Lordship.
What kind of proceeding? Huh?
Criminal entire proceeding, Lordship.
Criminal?
Entire proceeding.
No, what kind of proceeding?
Lordship.
I know it is before the criminal court, definitely criminal proceeding.
Yes.
So what category of proceeding? Matrimonial, commercial, what?
That is a.
Huh?
Court of-
Okay, let us read the first information report. Then I'll
Page
understand.
21, Lordship.
Page
Page 21.
21.
Purely civil. Kindly see.
With regard to the subject matter, I would like to lodge a complaint against Madhurya Gogoi resident of Abuchalgaon. I would like to state that I am a registered contractor. There is a proprietor of Gihang Engineering Private that for my contractual work of zoology and as well as business. But should be connected so made a payment.
You can just same area, may submit.
1 minute, 1 minute. So this petition I wrote. I think you go. What is this page 41?
Page 41. Page 41, this is second FIR loss. For the same cause of action, same informant, same amount, another FIR was lost against them
Okay.
by the complainant. Again, the same amount lost. In dispute PS. The first one is the another PS. Thereafter the complaint lost complainant lost the FIR in dispute PS.
That was also searched.
That was also trial is going on. Trial is going on. What the styling is another is NI case also one file against the petitioner for the same allegation or same amount lordship.
Same amount.
Same amount.
NI case.
The allegation is amount is same, but the
Amount.
That is
Take amount is what?
Take amount 10 lakh. Here is allegation that
He made payment.
here is allegation 13 lakh. He paid to the petitioner, but in check in NI case he filed.
That is going on. NI going on.
That is also
Two FIR both searched. Different police station.
Different police station.
Now which one you want Quashing?
The Damaji PS case. First one.
Damaji, page 21.
Page
Yes, madam.
Lordship, I am appearing on behalf of SK Hassan Mohammed. We are for respondent number 2. He is not present in the court due to some personal issues. So,
Personal issues.
sir, there is flood in his area, so he could not come.
Flood. That is okay. Agreeable.
Earlier they have taken his.
Flood will receive tomorrow.
Maybe, sir, if the weather gone.
Weather got permitting.
Earlier they taken step. Sorry, the adjournment lordship. My humble prayer before lordship.
Hard. We keep it Tuesday. Tuesday, part hard.
Lordship.
Absolutely.
Amount also,
Absolutely same.
Amount also paid.
3 proceedings for one.
Amount also paid, lordship.
Amount paid.
Lordship.
Where?
Some portion of some amount also have to pay.
Anyway.
That is a page.
3 proceedings cannot go on.
Page 55.
And when the second FIR where is the proceeding going on? Second proceeding is going on before which court?
Largest CDM lordship.
Second FIR.
Second FIR that is going on before the Larnet Metro lordship in.
Accused present. Where is the order?
That is page lordship. Before the lordship. Before that, judicial measure first class Kamrup Metro lordship.
This one, page 54.
Page 51 lordship.
Huh?
Yes, lordship.
And what is the stage of the proceeding of this case?
This one is, I have filed a quashing petition and now is, that is a stay, dishonor.
Issue some,
Stay-
cognizance taken,
Cognizance of taken, such frame,
page 37,
test certain as a such frame, Lordship.
page 37.
54, sorry. 54 is a such frame order, Lordship.
Huh?
Page 54 is a such frame order, Lordship.
No.
In second FIR,
Mr. Counsel,
Lordship,
come to page 37.
37, Lordship. Page
You are seeking quashing of this page 21, right?
Yes, yes, Lordship.
It is, PRC case number is what?
PRC case number, Lordship, sorry, 7022.
Okay. And second FIR is at page?
Page 41.
Page 41.
Yes, Lord. And suspend order. Lord.
He seems to have good connection in police.
Yes, Lord.
Right, Mr. Goswami? Looks like he has good connection in police. So second FIR 41 and PRC case number is page 54.
54.
And same set of allegation.
Same set of
See, Mr. Goswami, page 54, no ingredients of 406.
Lordship.
Cognizance under section 420. Now turn to page 37. 420 and 406.
Yeah. Suspend here, first one is.
Will he be available tomorrow?
Maybe, sir.
There is nothing to be heard still.
Can we have 1 week?
Why not 1 week? Okay, Tuesday. Heard Mr. B. Islam,
Lordship.
Learned Counsel for the petitioner, and Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent state, on the prayer of Miss
Farnaz N.A. Hussain.
Learned Counsel appearing on behalf of Mr. S.K. N. Mohammed, Learned Conducting Counsel for the respondent number 2. The case relisted
Can it be
on
20, Lordship?
Tuesday or 20.
20, Lordship, can it be?
For the per day.
20, Lordship.
Huh?
Can it be 20? Lordship,
20.
because 18,
20.
I have to go to damage, this fast is fixed on.
20.
20, not.
You remind me.
Lordship.
Morning. Make a mention at 10:30.
Item number 24.
Yes, what has happened to Bhaiti Mystery?
Lordship is convicted under section 10 of POCSO and 354 IPC.
Okay, will issue admit heard Mr.
AR3.
AR3. Learned Counsel for the accused appellant. Page
23.
23. And Mr. M.P. Goswami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam.
Left.
Page 23. Judgment and Order 28/5/2025. Additional Session Judge come Special Judge POCSO Morigaon, Oregon Special Court. POCSO case number 114/2019, which arose out of Morigaon Police Station case number so and so. Page 46. Convicted under section 10 POCSO Act and 354 IPC. These two?
These two.
POCSO, rigorous imprisonment 5 years, fine of rupees 10,000, default stipulation. 354, 5 years, 5,000, default stipulation. The sentences are ordered to run concurrently. I have gone through the grounds urged in the memorandum of appeal. The appeal is admitted for hearing. Yes, records of so and so be called for issue notice. As Mr. Goswami for respondent number 1. For 2, practice direction. Additional public prosecutor obtain report as regards service of notice from the officer in charge, so and so police station, and to place the same on the returnable date.
25.
Yeah, please, Your Lordship. So this is revision petition is due to rejection of a Jimma PI, Your Lordship. Your Lordship, one report was called for from the investigation officer, Your Lordship.
Report we have not received, my lord.
Hmm?
Report not received regarding the.
Okay, G. Bora for the petitioner is present. Mr. Goswami, MP Goswami, an additional public prosecutor for the respondent state of Assam has submitted that. You submitted all those documents?
Lordship, we approach, Your Lordship, they denied to take my documents, Your Lordship. The
What,
police.
Mr. Goswami?
We on
Lordship,
the very
Lordship.
next day, Your Lordship, we approach, Your Lordship. As per Honorable Court's order, Your Lordship,
No.
but they denied to accept my documents, Lordship.
Make an allegation on affidavit.
Lordship.
Submitted that he has not received the report as called for,
No.
comma, from the IO till date. He has sought for how much time?
Lordship from Nagaon, my lord. Any date after, my lord, in September, my
He has sought listing of the case on
on 4th, my lord.
4th September 2025 to enable him to obtain the report. List the case accordingly on 4/9.
Exact, my lord.
Item 26. Please, Your Lordship. This is a criminal appeal. Listed for the first time, actually.
Criminal appeal, where is the judgment?
Judgment is at my lord. Page, it starts from page 9.
Page 9.
Yes, and order, punishment order is at page.
How many appellants?
Only one, my lord.
Only one.
Yes. Accused and convicted are there, many.
Minute. How many accused? 24.
Yes.
That judgment, it was tense. You are
I am 24.
Hemanto.
Triple one is the order, punishment.
Hemanto.
Hemanto Dema.
In the table where you are. Seal number?
24.
Okay.
Page number 111 is the order, punishment order.
So 3 months.
3 months, yes.
Huh?
Yes. And I have already served.
1 month, 28 days.
Yes.
Okay. Heard Mr. Deacon. Learned counsel for the
D6.
accused appellant. And Mr. M.B. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. This criminal appeal under section 415 B in SS is preferred against a judgment dated 15/5/2025 and an order on sentence dated 19/5/2025 passed by the Court of Learned Sessions Judge Soraidev at Sonari Trial Court in Sessions within bracket S-C case number 187/2012. First off, by the judgment and the order on sentence, comma, the accused appellant, the trial court has inter alia convicted the accused appellant for the offense under section 202 IPC, and he has been sentenced to undergo rigorous imprisonment for a period of 3 months and to pay a fine of rupees 3,000, in default of payment of fine, to undergo simple imprisonment for another month. I've gone through the grounds urged in the memorandum of appeal. The criminal appeal is admitted for hearing. Case records of sentence will be called for. Issue notice returnable in 4 weeks. As Goswami has appeared and accepted. Respondent number 1, extra copy 3 working days. The accused appellant shall take steps for service of notice on the respondent number 2. by registered post to JD as well as by usual process within 3 working days. Heard Mr. D.K. Nath, learned counsel for the applicant appellant, and Mr. M.P. Goswami, learned additional public prosecutor for the opposite party, the respondent state of Assam. Post of the instant application under section 430 within bracket 2 BNSS is prepared by the appellant seeking suspension of execution of the sentence passed against him and for his release on bail. Whereas the applicant, as the applicant has not prepared the accompanying appeal, means so and so. It is admittedly, during a period of investigation, the applicant appellant has spent 1 month, 28 days in custody. Post of judgment to go fixed term sentence, so and so, so and so. Yes, how much?
20,000 will do,
20,000. Once you fix
months.
Till the disposal of the appeal. Item 27.
Yes. Offense
304B, Lordship.
304B period.
10 years.
Huh?
10 years.
10 years. We have to issue notice then. Ayu Choruri. Accused appellant. MP Goswami. Respondent state of Assam. Judgment page.
Page 12, Lordship.
Page 12. Judgment dated 14/7/2025. Order on sentence dated 18/7/2025. To additional session judge, Borpeta. Special court. Trial court. Sessions case number 165/2021. 304B. Rigorous imprisonment for 10 years. Any fine?
No, Lordship. Finding not there.
Okay. 10 years. Again, you had bit hearing. Respond number 29. Heard Mr. Ayu Chaudhary. Applicant appellant. MP Goswami, opposite party respondent state of Assam. The instant application is prepared by the applicant appellant seeking suspension of execution of the sentence passed against him and for his release on bail. Issue notice returnable in 4 weeks. As Mr. Goswami has already appeared and accepted notice for the so and so, no formal notice is necessary. One copy within 2 working days. The respondent state shall file its objection, against the instant application on or before the returnable date, if so advised.
Item 28.
Pass over the matter for timing.
Not timing, sir. Today we have to reach, we don't upgrade this one.
Only the matter will take hardly 5 minutes in court number 24. It's going on.
We don't know.
But if my senior will come.
But it will not be called midway.
29.
Your Lordship, notice was issued, Your Lordship, and
Okay, Google passed earlier. You are enjoying some interim order.
Lordship.
Reminder, yes.
Respondents.
What was the issue?
Issue, Your Lordship, we have.
Issue
pending
reminder.
the
Oh,
proceeding, Your
yes.
Lordship.
SC has come or not?
LCR is.
Scan copy, TCR
29.
LCR received.
received. Okay. And respond number 2,
They entered appearance, but today they.
Quashing,
Lordship.
what is the prayer?
Quashing.
Quashing or proceeding?
Proceeding.
Complaint or what?
Not complain, your lordship, it is
GR case.
GR case, your lordship.
Since they have not come, let us have on another date.
Lords.
You enjoy your interim order. As brought a counsel for the petitioner and Mr. MP Goswami and additional public prosecutor for the respondent one state of Assam are present. Though the respondent number 2 has entered appearance and the names of the land councils are reflecting the causal stand has appeared today on call post of let the case be listed after 2 weeks in view of non-appearance on the part of the respondent number 2. On the interim order past side, shall continue till
Lords.
the next request.
Item 30.
Yes, sir.
No, this is the petition, Jimma petition, my lord.
Jimma petition.
Yes. Report was called for in this case, my lord.
Yes. What kind of
This is vehicle, my lord,
Mahindra
vehicle.
Jailo
Yes, my lord.
report? What kind of document you have?
My lord, I'm the registered owner. my lord.
Registered. And what kind of offense?
This is, my lord, the Essential Commodities Act, my lord. That's why probably your lordship will find page 16 is the order of the.
Yes, report.
The report has come, my lord.
Huh.
That the case has already been suscited, my lord.
Huh.
That a report. And as per the report, registered owner of the vehicle is one Bodhi Jamal. That is what the report.
Bodhi Jamal.
Lordship.
It's subsidies, but my lord, I don't think the
Other-
vehicle is necessary for any other purpose.
Yes.
Yes, but it was not reflected whether it required or not. Only
Tell
that
me what is the
Yes.
when it was seized?
it was seized.
Seized,
Seized
my lord,
category.
10 to 25. 10 to 10 to 20.
Let us see the affair.
Yes.
Lordship.
অমৃতলানে কি আছে আছিল গুজৰাটৰ দিবচোন চিজাৰৰ কিতাপ ইকো বাঞ্চ এটা আছে ন বাঞ্চ এটা আছে ন 11 to 2000 page 9 FIR.
Yes. This. Seizure is at page 11.
Let me read the FIR first. So you transport oil, smuggle oil.
That is the allegation.
Mahindra Jailo. He was not there.
My lord.
Owner was not there.
Yes, as per the my lord.
As per the FIR.
FIR, my lord.
13 number of plastic drums.
60 liters capacity is.
Hmm. And 2 number of plastic drums. Good. 800 liters.
Okay.
Why you did not submit your original documents?
The first of all, my lord, I submitted in the next case, my lord, page 16. Here I submitted the, my lord, but that was rejected only on one reason, my lord. Page 17, my lord. Citing a Supreme Court judgment in Omram versus State of Rajasthan. That, my lord.
Page 16.
Yes, my lord.
Page 17, my lord.
17 is the reason, my lord.
Yes, record.
This is clarified by this.
No.
And the grounded 2018 5 HCC 502 observed that certain provisions of essential commodities. like-
Earlier, a report was called for from police. Did not turn up. The recording prayer was rejected. Now, reject this. What do you say?
My lord, that question has.
Supreme Court or?
Yes, that question has been clarified by this honorable court, my lord. If no confiscation proceeding is there, so it will not take.
Look at it.
Para 6. Para 6, my lord.
What is a search sheet?
My lord, the receipt has been submitted.
Oh, if the petitioner is charge-seated or not charge-seated? But because if he is not charge-seated, then he is definitely entitled for this thing. Get the instruction. Yes, tomorrow, can it be?
Otherwise also, my lord, if confiscation.
Okay, no, let us be clear.
No, my lord, I'm not on that, my lord.
Definitely.
Yes, if confiscation proceeding is not there,
Ah.
then if confiscation proceeding is not there, no.
Try
Let's
on
take
Friday,
Tuesday.
the Wednesday. We'll make specific. Heard Mr. J. Pine, Land Counsel for the petitioner. And Mr. MP Goswami, and additional public prosecutor for the respondent state. Post of Mr. Goswami, and additional public prosecutor has submitted that. The case number?
That's yes, number.
The case in Bisni Police Station case number 25 stroke 2020 to 15 stroke 2020 has already resulted in a charge sheet. By charge sheet number, comma, he has sought time till Wednesday to obtain the necessary instructions in a matter. Post of Mr. Goswami shall place the details of the charge sheet, including the persons charged therein, and specifically whether the petitioner herein has been charged or not. Post of place the case on Wednesday. We'll pass that order on that.
31.
A2 A2 light 31. File of bitter, A2 talking through a liquid. Huh? Huh? Ah. A2 one. A2 koila hai. Yes.
May I please, your lordship? Lordship, the respondent number 2 has filed an affidavit and affidavit against us, and the affidavit we have just received it yesterday, and it is not on record as well. So we are asking for another deed.
Your name, please.
R. Borgohain on behalf of
R?
NK Das. R. Borgohain on the behalf of NK Das.
R. Borogupai. As Land Counsel of petition has submitted that the respondent means okay, the respondent has filed an affidavit recently, and the said affidavit is not part of the case record. It is submitted that the case be, it is, Ms. So-and-so has thus sought listing of the case on another date with the said affidavit on record post of Miss as thus. Be sure that counsel for the respondent is present. Place the case after a week. On date to release by the office. Any interim order you are enjoying? No.
Obligation.
32.
Lordship, I'm appearing on behalf of my senior A.K. Bhuya.
Hmm?
I'm appearing on behalf of my senior A.K. Bhuya. The respondent.
You filed your response. You have filed?
We have filed an IA.
IA. IA ki is a sound. Yes.
Lordship, we need 3 weeks time to file a reply.
Not 3 weeks. Criminal case. Criminal case won't take 3 weeks. You file a big one. What? So many judgments and all. Family good. Kaji.
125 profit. That is the file on 2013. And the Honorable Supreme Court, my lord.
I find 125 proceeding very difficult to adjudicate. Anyway, when you want.
3 weeks.
What is the stay?
Entire proceeding has been stayed. On the ground that, my lord, they filed application at the time of argument stage, my lord. But you can see their petitions.
No, I'll see the stay order.
Is
Your wife
possible.
and you're paying 18 lakh tax. Something like that, they have still, they have a list.
There is no record.
He's saying income tax payment. Okay, you're Mr.
Case, my lord.
I Bhattacharya. I Bhattacharya.
I would say. Learned counsel for the petition has sought 2 weeks' time to file an objection to the interlocutory application I criminal 785/2025. Mr. R. Ali, learned counsel for the respondent number. Respondent. Applicant respondent is present. Has submitted that an interim order is in operation. Full stop. As sought for and as agreed to by the counsel for the party, release the case on after 2 weeks. The interim order passed, I guess, shall continue till then.
Item 33. May it please, my lord. My lord, this petition filed for quashing of the FIR as well as charge sheet.
Erjahar,
Yes, ma'am.
charge sheet, entire proceeding.
Yes, ma'am.
447.
The amicable settlement was
354. 506.
354 is a non-bailable.
Huh?
354 is a non-bailable section.
323427. Who is respondent number 2? Yes, what do you say?
Intervention of the other.
Okay. You have no issue. 354?
Yes,
What do you say? Non-compounded, okay. But not outside the purview of 482 perhaps. If the lady is examined as a witness, she would be saying nothing. So 354 would not remain outrageous personal. Kali order to some, but I don't know.
There is some judgment.
This is the agreement. Bombay High Court. এটা তাতে উপরে নিয়ে লেখা আছে
Para 20, my lord.
আমাৰ সুপ্ৰিম কোৰ্টৰ যিবোৰ আইন আছে ওলোৱা হয় ন তাতে ওপৰত এনেকুৱা এটা লেখা আছে যে sexual offensive settlement কৰিব পাৰি পেনেৰে লেখা আছে What is the level of allegation? Yes, Mr. Soma heard Mr.
M. Kolita.
M. Kolita. All right, counsel for the petitioner. B. Sharma, additional public prosecutor for the respondent number 1, state of Assam, and Mr. A. Hukan, counsel for the respondent number 2. Post up. The criminal petition under section 528 B and SS is preferred, seeking setting aside of the entire criminal proceedings of police report case, PRC case number 422/2021. Presently pending before the Court of Learned Chief Judicial Magistrate Baksa at Mosalpur Trial Court. And also the first information report dated 15/1/2021 registered as Mosalpur Police Station case number 05/2021 and charge sheet, charge sheet number 22/2021 submitted in that connection on 30/01/04/2021. Post up. Para. The respondent number 2 hearing as the informant lodged an affair before the in-charge Dumni Outpost Police Station Mosalpur on 15/1/2021, naming two persons as accused with the present petitioner as accused number 1, post up, in the affair, it was interiorly alleged that at around 7:30 p.m. on 15/1/2021, the two accused persons suddenly attacked the house of the informant, respondent number 2, that's informant, and they were armed with iron rods and knives. At the time of the incident, the informant's husband was not present. Post up. By trespassing into the house without permission, the accused persons had allegedly vandalized the household items. Post up. That apart, they also pulled and dragged the informant and using obscene language. The informant further alleged that the accused persons also tried to drag her towards the forest located behind the house. Post up. It was the villagers who arrived at the scene at that time, and seeing the villagers, the accused persons fled from the scene. Post up. Para. On receipt of the FIR, Dumni Outpost General Diary entry number 44 dated 25/1/2021 was registered by the in-charge Dumni Outpost while forwarding the FIR to the officer in charge, Musalpur Police Station, to register a case. Post of upon receipt of the FIR, the same was registered by the officer in charge, Musalpur Police Station, as Musalpur Police Station case number 05/2021 under sections 447, 427, 354, 294, 506 of the Indian Penal Code on 16/1/2021. Post of the investigation was entrusted. An investigation ensued. Post of on completion of investigation, the IO submitted a charge sheet under section 173 CRPC by charge sheet number 22/2021 on 30/04/2021, finding sufficient incriminating materials against the petitioner to face the trial for committing the offenses under section 447, 427, 325, 354, 294, 34, IPC. Full stop. You are the only one?
Yes, my lord. Other is juvenile, my lord.
Huh?
Other is juvenile.
Okay. The other accused person named in the FIR was found to be a juvenile. Post up. Para. On submission of charge sheet, the case has been registered as police report case PRC number 422/2021, and the case has been transferred. Oh, sorry. Okay. And post up. Before the has been registered before the Court of Learned Chief Judicial Magistrate, Baksa, Musalpur trial court again, huh? Post of the trial court issued process to secure the appearance of the petitioner as the accused. Full stop. On receipt of summons, the petition appeared before the court. Full stop. The parties were heard for framing of charge. Full stop. Finding prima facie materials against the petitioner, accused petitioner. You don't know. I'll keep my silent number. Charges under section 447, 354, 506, 323, 427, IPC read with section 34. How many? 34, how 34 came?
There is, my lord, two accused, my lord, but one is juvenile.
Huh?
34.
Okay, 34 IPC were framed. Post of when the charge was read over and explained to the accused petitioner, he pleaded not guilty and claimed to be tried. Post of. As a result, the case proceeded to the stage of trial, proceeded for trial and for recording of evidence on 1/10/2022. Post of. Para Mr. Colita, learned counsel, appearing for a petition, accused petitioner, a petitioner has submitted that in the meantime, has submitted that during the period of investigation, a process of mediation was going on between the parties, and it was at the intervention of the elders from both the villages and well-wishers, the informant and the petitioner, informant side and the petitioner side, decided to bury the hatchet in the greater interest of maintaining peace and tranquility in their locality. Poster. As a result, the disputes and discords existed between the parties have been amicably settled, and to that effect, the respondent number 2, that's informant, has voluntarily come forward to execute and swear an affidavit on 9/6/2025. Poster Mr. Quilter has referred to the said affidavit annexed as Annex 3 to the instant petition, to support his submissions. Poster para Mr. Fukon, learned counsel who has appeared for the respondent number 2, that's informant, has submitted that as the informant side and the petitioner side are from the nearby localities, the village elders had intervened in order to reach an amicable settlement between the parties, so that peace and tranquility in their respective localities are maintained. Post-op. He has submitted that the respondent number 2, as informant, and the petitioner have both amicably settled the issues by arriving at a compromise. Post-op. He has, Mr. Fukan has submitted that the affidavit annexed as Annex 3 to the criminal petition has been sworn by the respondent number 2, that's informant. Post-op. The power of so and so in liquidable. Other than the offense under Section 354 IPC, other offenses are compoundable. The other offenses under Section 447, 427, 327, 294 of the Indian Penal Code are compoundable as per the provisions of Section 320 CRPC. Post-op. It is only the offense under Section 354 IPC which does not fall in the category of compoundable offenses. Post-op. Powers 482 লিখি দিব, Lakshmi Naran লিখি দিব, এটা লিখি দিব, কালি হেৰি দিছো অনন্ত। Having heard
294 is non-compoundable.
Okay, 294. 294.
354.
294 add করে দেব, 350 পড়ব। having regard to the materials brought on record, including the affidavit sworn by the respondent number 2, that's informant, comma, and hearing the learned counsel for both the sides, comma. It is evident that the respondent number 2, that's informant side, and the petitioner side have already arrived at an amicable settlement with regard to the disputes and discords between the parties. First of though charges were framed against the petitioner in the proceedings of so and so case number, PRC case number 422/2021, comma, it is the testimony of the respondent number 2, that's informant, which is vital to bring home the charges under section 354 IPC and section 294 IPC, since as per the version in the FIR, comma, at the time of the incident, comma, she was the only person who was present inside the house. Full stop. If such situation, the such situation is taken into consideration, comma, there is the possibility of the case resulting in conviction against the petitioner for the offences under section 354 IPC and 294 IPC is a bleak possibility. First off, as the two sides have buried their hatchet at the intervention of the village elders of the localities by arriving at an amicable settlement, comma, this court is of the considered view that the criminal prosecution in connection with PRC case number so and so is to be given a quietus. So therefore, in exercise of the inherent powers under 528 of the BNSS, the proceedings of so and so, case number so and so, set aside the originally question originally the question proceeding of PRC case number pending so and so is set aside in past. Consequently, the FIR and charge sheet are also passed. No upgrade.
Yes, I'll take just an accommodation for, because in spite of my lordship, several orders. In spite of your lordship, several orders to give a report in respect of the gym, my cash.
Tell me which date?
Yes.
All this.
21.
21. Who did? 21. Oh, BD Core, Senior Counsel.
28. Obliged.
20. Item number 20. Item number?
28.
28.
Yeah, obliged.
Date 21.
Obliged.
Items 34 and 35.
Yes.
Lordship, you kindly have order dated 25/7/25, my lord.
25/7.
This is the case your lordship had heard, my lord. My period of detention was extended, my lord, under section 36A(4) of the NDPS Act. And I was not put to notice, my lord, and I was not even heard. This is the
1
requirement.
minute. What order you want to
My lord.
see me?
25/7, my lord.
Yes, Mr. Sharma, here is received. Take your call. Hmm. No, there are, firstly, I do, subject to correction, that day I granted one. Firstly, I don't know. Who has submitted the application?
PP.
Okay, PP,
That
that
part
is
is
gone, that is okay. Prior to 180 days.
Prior to 180 days. That part is. 170.
Now, he is in custody. He is in custody. Three things, at least it has to be brought to the notice of the accused that such an application is being moved. That is the most vital one.
My lord.
And it can be served also to the council.
My lord. Yes.
I think. Record. Should I see or you should see? You should see. If you don't cannot support your case, gone.
But my lord, the reason that has to be given for.
We'll go to the region later on. That is on merit. Here is the procedural formalities. 1, 2, 3, 4. Right? First is by PP. That is there. Right? Before 180 days, that is there. Accused must be in custody. That is there. Now it is notice. Notice that such an application is being moved for permitting the IO to increase the period of investigation beyond 180 days. So that 167 provision does not come into the aid of the accused. I think that is the main purpose. Otherwise, investigation can be carried out for 2-3 years also. Tell me, the record was called for only for that region, so that you can resist. Check. We are here. Not that, but still the result can come. Commercial?
Commercial.
Okay, which one is the report of the public prosecutor?
Report, your lordship.
That is the condition.
Condition, my lord. Report, my lord, is at page 35. Page.
No, regarding that notice to the.
Oh, my lord, judgment. My lord, first judgment is Hitendra Vishnu Thakur, my lord.
Hitendra
Vishnu Thakur, my lord, para 21. Internal.
Para 21.
Internal page 627.
Para 21.
21, my lord.
Precitam.
Page 627, my lord. And relevant portion starts at 628.
Any Precitam ABCDE?
My lord. No, yes, my lord. After F G, my lord.
G.
G is there, my lord.
Para?
Para 21, my lord.
Okay.
And regarding this extension part, it comes in the next page, my lord, from the fourth line.
One minute. This was under TADA, but same principle.
Perimeter.
So 21. Then,
Sanjay Dutt, my lord. Because in Hitendra Vishnu Thakur, it said notice. Sanjay Dutt made it clarified that it may not be a written notice, but accused has to be physically produced before the court.
para?
Para 45, my lord. Para 45. Internal page, my lord. 440.
This is unreadable.
My lord.
45.
45, my lord.
One part is missing, middle part is missing.
And this is another copy, my lord. Perhaps it will be there in the other connected matter, my lord. Another judgment, my lord. Copy of the judgment.
It was saying so.
Then I can read, my lord. I have given another.
No, this is perhaps submission.
No, my lord. Para
45.
45 is, my lord, in Hitendra Vishnu Thakur, it was held. And then
No, these are submissions.
Then, my lord, para 53, 2A, my lord, page 44. Finding is there, my lord.
Para?
53, my lord, page 444.
Hmm.
2A is there, my lord.
53.
2A, my lord. Section 24 BB of TADA, my lord. Third one, my lord, Sanjay Kedia is specific to NDPS, my lord. It starts at para 11, my lord.
Which one?
Sanjay Kedia, my lord, Sanjay Kumar Kedia. 2009-17 SCC 631, my lord. It starts at para 11, my lord. Relevant will be a para 13, 12 and 13, my lord.
Somewhere more, one more is that, serving, informing or serving
Upon the council.
notice to the council
Council.
is itself
Yes, ma'am. That
is
also-
good notice.
Yes, my lord. That is also there, my lord.
Recent, I have seen someone. But Mr. Nawaz, I had to rise. There is
My
a
lord.
meeting. There is a meeting.
My lord.
I have been asked to. Right. Someday else we will try. Shortly. Yes, anything positive?
On the particular judgment, at least my lord, 6/25.
26/2025. When the impugn order was passed?
3/6, my lord.
3/6.
3/6.
And my lord, you are, my lord, products of, 1 day, 8/6. This 4/6. 1 day, 4/6.
No, if the order is to 3/6
Yes, my lord.
and the petition was filed in 2/6,
2/6.
then it had to be before 3/6.
The impugn order itself is very clear, my lord. Nothing.
But to pass the order, you need you need time. Okay. Put it on Tuesday. Mark the pages if
Yes,
if you find something relevant,
yes.
right? Yes, no, it's be sure. List the case again on Tuesday.
Deeply obliged, my lord.
One more only. Yes, what is to be done here?
Lordship, this is a application, your the custody of a vehicle, your lord.
Custody of vehicle.
That has been rejected, your lordship.
Mr. Boda, you have to wait for 1-2 days.
Lords. It will get some call. This to kalju dina.
Okay, Mr. S. Bortku, Learned Counsel for the petitioner is present. Miss Anne Chudri, Learned Counsel appearing for M. Kumari. And standing as the CBI has made a prayer for adjournment, which the vice sought for and agreed to. Kom thaka date di diyo. Friday দিব পাৰে, next Friday.
Your lordship.
Khula আছে যদি.
Can it be on 20 or lordship?
Many cases, I don't know how
This
many
second
cases I have
lordship
fixed.
to NIA matter was fixed. Is fixed.
I- Then it will go later on.
21.
26 then.
Lords.
26. Be patient.
Lords.
Yes, any urgency to her listing, actually. I had to rise.
Lord, item 52, Lordship has already heard the matter at length. Day before
Thing
yesterday.
is that I could not complete.
Yes, ma'am.
Okay, some other day.
Maybe next week, my lord, if possible.
Item number 52. Paucity of time. BM Deka.
Yes, my lord.
Due to paucity of time, case could not be taken up today. Leave the case on so and so.
Much obliged, my lord.
Okay, Wednesday. Because tomorrow, second half, there is a division bench. So, and there are many motions. Yes, madam, Tuesday.
Tuesday, then Wednesday,
Wednesday.
I will be out of station.
Wednesday. Out of station, huh?
47.
Yes.
47.
Okay, yes, Hazarika J. Hassan, special PP. Okay. I was sought for and agreed to. There is the case on 22nd. 22nd. Deb. Item number? Deb, item number?
47 worship.
What date you are not available?
Monday and Tuesday worship.
Wednesday.
Yes.
Wednesday. Item number?
47.
47.
I am.
এইকেইটা দি দিব, এইকেইটা আই যিকেইটা আছে ন, এইকেইটা ফ্ৰেছ আইটেম যেন লাগিছে, ফাইলিং নাম্বাৰৰ সৈতে। এইকেইটা 41,
My lord, I am.
1 minute, 42, 44, 45, 46, 48. এইকেইটা এটা ডেটত দি দিব, হা? আৰু yes,
43.
43.
Lordship,
43 new item or old item?
admission, Lordship.
Side
Lordship,
board.
but I may be given liberty to file adjournment petition in the trial court because yes, tomorrow it was fixed.
Okay,
And it
Mr.
has given last-
Darakullah, learned counsel for the petitioner, and Mr. MP Gusami, learned additional public prosecutor for the respondent state is present. Due to paucity of time, the case could not be taken up today. First, Mr. Darakullah has expressed urgency in the matter as the case before the trial court is fixed on
tomorrow.
Fixed on so and so. First of, lays the case on so and so for consideration. Next week at video, so that you can.
My lord,
That this is the date.
item number 41 and 42, my.
And I have already said. I have already said. I am not repeating it.